Good morning, everybody. Welcome to this meeting of the Central Coast Council Hearings Panel for the 10th of December. There are no apologies, so we don't need to worry about that. And there are no minutes to approve. So we can move on to the first item on our agenda, which is item 24.12.1. It's for resource consent 240033 Natasha Williams. I can advise this is the properly convened meeting of the hearings panel called for the purpose of hearing a resource application for a land use consent for a second dwelling at Huntston Road. I ask the minute secretary to report on proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the planning officer has been circulated to address the service.
Thank you. The following procedure will be followed for the hearing. The panel may ask questions. Council's officers or its consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence. The Section 42A report writer will then be invited to provide a reply following the hearing of evidence and submissions. The applicant will then have a right of reply, but should not be permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask that all parties appearing identify themselves. Morning.
Morning, Commissioner. I'm Ben Russell, appearing as counsel for the applicant today. And with me, I have Mr. Peter Williams, who is appearing for the applicant as well. He's the father of the applicant. And also with me is Mr. Richard Tyler to my left, the landscape evidence, and Mr. Peter Priestman with planning evidence. And Mr. Ben Gresson with me from my firm, Queenstown as well.
What was, sorry?
Gresson, Ben Gresson.
Seen that name somewhere, thank you. Welcome, gentlemen. Forbidding all you guys sitting in front of us, all hell. Should be threatened or not.
More than us.
Oh, yeah, we had some reinforcements, I think. Yeah. No, welcome. I'm sure it's not like that. And we've got, I have a copy of your legal submission and a summary of Mr. Kloosterman's evidence and his evidence, the evidence of Mr. Williams, and the summary of Mr. Tyler and the evidence of Mr. Tyler. That's what I should have. Excellent. Always a good starting point. Right. Moving forward, then I'll ask for a motion that the Section 42A report be prepared by the planning officer, be taken as read. Move Martin, seconded Ian. All in favour? Aye. Against, carried. And I'll pass over to you, Mr. Russell, to take us through your applicant's submissions.
I've introduced the experts ourselves already. These submissions are presented on behalf of Natasha Williams, the applicant, and supported by RC 240033. The applicant seeks resource consent to construct a second residential dwelling in the resource residential area at 353 Huntston Road, Alexandria. The application was lodged on the 28th of February. Evidence in support of the application, as I've stated, will be called, has been provided by Mr. Williams as lay evidence / applicant, Mr. Kloosterman with planning evidence, and Mr. Tyler through landscape evidence. By way of executive summary, the applicant's case is that the application is, in its advice form, has set out in evidence is appropriate for the grant of consent, given the application will maintain the rural amenity values and landscape character of the site and the wider context. The cumulative effects of the application will not be more than one. Breaches of the skyline views from the proposal are minor and barely discernible from the Dunstan Road context, and the application is consistent with the objectives and policies of the district plan and the Act, and Part 2 of the Act. The landscape evidence of Mr. Tyler should be preferred over the assessment in the Section 42A report, given Mr. Tyler's qualifications and experience as a registered landscape architect and his landscape methodology used to assess effects. On the basis of Mr. Tyler's uncontested expert landscape evidence, the proposal will have a low to very low effect on landscape character, cumulative effects, bulk and visibility, and will overall maintain the landscape and natural character values of the district's rural areas. The revised proposal tabled by the applicant will ensure that the visual effect of the form of the proposed dwelling is much lower than that which was assessed originally in section 42A, and this will be spoken to by Mr. Tyler in the summary of evidence. The dwelling has first of all been rotated 90 degrees, so the broad side of the structure is not facing. The building has been shifted further into the site, increasing the setbacks and I should say decreasing visibility from the road, by effect being further set towards the hillside, and ensuring that screening of the building is secured by way of an amended landscaping plan demonstrating the retention of mature vegetation. The above revised proposal ensures that landscape character and visual amenity values for the site and its wider context are maintained appropriately, and that views of the proposal from the road are sufficiently mitigated. The revised proposal further decreases the previous breaches of the proposal skyline, such now that Mr. Tyler concludes that those builds are minor at most and very difficult to perceive in the context of the proposal. No countering expert landscape evidence or opinion or review has been provided to suggest that different level of effects arises, and it's respectfully submitted that the hearings panel should adopt the available expert evidence before it. Moving on to the site and environment context. Are the commissioners familiar with the site at all?
To the extent that I know where it is, I've driven past it on many occasions, and I have been past it as part of this. No more detail than that. I could say it's yeah, you can see the trees and the
Yeah. I'll run through the context from the site. The site is located on the northeastern side of Dunstan Road, which, as you will know, runs northwest to southeast parallel with the state highway. The site is zoned rural residential, and it also falls within the Vincent spatial plan and complies with the spatial plan's rural residential directions for densities. And maps to this effect are provided in the original evidence lodged by Mr. Kirsten. There are various rural activities taking place in the surrounding context, with properties being subdivided for rural residential users. Nearby dwellings are mostly located near the roadside boundary of their respective properties, are largely screened with significant plantings. The applicant has sought consent for a specific proposal, being the high quality architecturally designed dwelling that will have a unique rural vernacular and character. The design will accord with the rural living and rural character of the site and the wider surroundings. Although there will be limited visibility, glimpses of the dwelling through the of a rural character building that is integrated into its landscape, context, and surround. Mr. Williams' evidence for the applicant sets out the reasons for the proposal and a particular design approach for the dwelling. The dwelling design is unique, made from a high quality materials and has historical significance. This makes it an exceptional structure to the site, alone with both practical and heritage considerations. It is the applicant's submission that, taking into account the contextual rural living environment, the expert evidence, and the below submissions, the application is appropriate for the site and should be granted consent on the conditions as proposed. Moving forward to the legal principles associated with the application. Firstly, the permitted baseline and existing environment. The Section 42A report does not apply any permitted baseline to the consideration of effects under the RMA. The reasons cited are that there are no permitted residential activities for the site, nor the building, nor for buildings that would breach the skyline. While that is the case for residential activities, there are relevant permitted activities for non-residential farm buildings within the site, which would contribute to the effects in terms of built form, cumulative landscape effects, and landscape character. It is my submission, given the rural character and design of the dwelling, the application of the baseline in this context is of some assistance. It is not fanciful to suggest that a further rural shed or non-residential building could be constructed on a rural living property such as this. In fact, previously the Environment Court has suggested questions along the following lines, which I will take you through, would assist in determining whether the baseline test should be used. Firstly, if the district plan provides for a permitted activity, or activities from which a reasonable comparison of adverse effects can be conceivably drawn. Whether the evidence regarding the proposal and regarding non-fanciful development under permitted activity is sufficient, whether it's sufficient to allow for an adequate comparison of the adverse effects, if the permitted activity with which the proposal might be compared to, whether the adverse effects nonetheless so different in kind and purpose within the plan's framework that the permitted baseline ought not be invoked, and might the application of the permitted baseline have the effect of overriding part 2 of the RMA. However, these questions are not a threshold to be passed before section 104 can be invoked. Quoting from Littleton, the case reference in the footnote below, they go to the single question of whether it is possible and sensible to embark on a comparison, or whether it would be notional or even a fanciful exercise. The key question from the above case law guidance is whether your discretion as commissioners not to apply a baseline should be exercised because the non-residential building would be a fanciful or so different in kind of purpose in terms of effects that the comparison with the current proposal is not useful. In terms of a comparison of a non-residential building, it is submitted in this instance that although the use or activity is different and that it's a residential use structure, the visual effects of the building will be very similar, particularly given the barn-style architecture and rural vernacular of the proposal. Although the skyline breach would trigger a discretionary consent, which would therefore not be applicable for consideration under the permitted baseline test, a slightly lower rural building of similar footprint to this proposal would equally have potential for effects on landscape character, bulk, location, and cumulative effects. Even if you choose not to exercise your discretion to apply the permitted baseline, it is the applicant's evidence that the effects of the proposal are minor or less than, and are suitable for the grant of consent according to the relevant objectives and policies of the rural residential zone as set out below. Effectively, the proposal does not hang on the permitted baseline, but it may help to make your decision easier. Moving on to the qualification of the experts. In the Council Section 42A report, in summary, it makes the following findings and recommending that the application be refused. The effects of the application on rural amenity values, character and visual effects would not be appropriately managed, particularly given the application fails to avoid the adverse effects in skyline. The bulk and location effects of the application have not been sufficiently mitigated. The cumulative effects will be minor, and overall, the application does not have acceptable effects on the rural character of the area. In making these findings, however, Mr. Vincent has undertaken an assessment of landscape effects of the initial application as lodged, and particularly based on the site visit during winter. Noting that the current application for you is altered, which we can get into. Firstly, it was observed by Mr. Vincent that the poles on the site were slightly shorter than the height of the dwellings as proposed. The applicant is grateful for Mr. Vincent's observations and in response has prepared a visual model of the revised proposal within the site to provide a more accurate assessment of the landscape effects. And this is shown in the evidence of Mr. Tyler. Mr. Vincent may now have changed his position as to adverse landscape effects on the revised proposal and further visual modelling now provided. I can't speak to that right now. But however, to assist the Commission, submissions are made below in relation to the relative weighting that should be given to the competing landscape effects assessments. On the basis of these, the applicant submits that greater weight should be placed on Mr. Tyler's conclusion. Firstly, Mr. Vincent's assessment appears to have overlooked the planting proposed to be retained by the applicant in order to mitigate visual effects. And Mr. Tyler's initial landscape assessment of a condition to retain 75% of all existing trees within the 50-metre setback from Dunstan Road. And the retention of the trees is now experienced here in Mr. Tyler's evidence and landscape plans, where it in case it was in this. On assessing cumulative effects, Mr. Tyler states that the application is consistent with buildings anticipated within the rural residential zoning, with screening providing a framework for increased density, much like similar screening in nearby properties. However, the report disagreed with this assessment, stating that the dwelling stands out significantly from the surrounding landscape, increasing bulk and location effects, and that the density levels of the area are almost above those anticipated in the district plan. As Mr. Tyler confirms in his evidence, the dwelling skyline breach will now only be visible for short sections of Dunstan Road, where users will be driving at 80 km an hour with the dwelling screened by the trees. This breach is characterised as ranging as imperceptible to minor, and with a very low landscape character effect. This is shown in Mr. Tyler's evidence, the viewpoints 2, 3, and 4. Mr. Tyler has used a planning methodology supported by the New Zealand Institute of Landscape Architects, with a 7-point rating scale set out in the evidence. The report has not referenced the use of guidelines and coming to the conclusions that it makes. It has not referenced that coming to the conclusions on the relative levels of adverse effects. The Tangi Te Manu supports the use of visual simulations for effects assessments, and in my submission provides a more accurate depiction of the proposal in the context compared to Mr. Vincent's reliance on the static photos taken only in winter. Moving on from these differences in approach, as far as council is aware, Mr. Vincent does not have the landscape architectural qualifications. It is common ground that the council and the court should be cautious to apply greater weight on evidence on landscape from a lay witness or from an expert qualified on a different field. In this instance, Mr. Tyler's evidence has been prepared according to best practice methodology and is consistent with national guidelines for landscape assessment, and now provides a more thorough visual simulation than that which is within the Section 42A report. In the absence of an expert landscape evidence from a suitably qualified and experienced landscape architect, to the contrary, it is the applicant's submission that the landscape evidence of Mr. Tyler should be preferred over the Section 42A report. The above is therefore relevant in the further discussions as to relative landscape and rural character effects, which will be discussed below. Moving on to the assessment of Section 104 of the Act and the effects of the activity on the environment. Firstly, the landscape character and visual effects, largely the skyline breach. The application will have a very minor proposed breach to Rule 4.7.60.b of the district plan, as the proposed dwelling is in the revised position. As shown in the evidence of Mr. Tyler, it is partially visible against the skyline when viewed from particular locations on Dunstan Road. This breach requires consent as a restricted discretionary activity, noting overall that it's assessed as a discretionary activity. Council's discretion for the skyline breach is limited to the following matters. Firstly, whether or not the building or structure can be appropriately screened from public view through topographical features, planting, and other screening, having regard to the open space, landscape, natural character, and energy value. Whether the building or structure will breach the form of or eventually implement in public view of the skyline heritage. And thirdly, whether the colour scheme for the building or structure should in general be darkened in the background, which is set. The skyline breach is considered throughout the report by Mr. Vincent, and as is seen in the report, is one of the overriding reasons why he considers the application does not appropriately manage effects on the report community values, character, and visual effects. That decision made now has stated instructions based on the revised proposal. Again, I can speak to that. However, the skyline breach rule does not appear to be as part and part of a rule as the Section 42A report makes out, particularly where the report states that other structures are tucked below the skyline from public view, and where it states the skyline breach is an important factor of the design. As stated above, council has discretion as to the skyline breach, with the most relevant factor to this application being the appropriate landscape mitigation. The skyline breach rule does not set an avoidance type. It's rather to be assessed on its merits and according to appropriate mitigations and by having regard to the landscape, natural character and amenity values of the environment. It is submitted that the latter drafting of the rule is particularly important as the context of the proposal drives character and therefore relative effects which are to be assessed. In the context, Mr. Tyler has assessed the remaining breaches of the skyline to be minor and with low overall effects on landscape character. Those conclusions are made with reference to A, the vegetative rural lifestyle surrounding the site, B, the imperceptibility of the breach when travelling at 80 kilometres down Dunstan Road with vegetation behind the dwelling, mostly screening the terraces behind. And C, the oblique nature of the view and the fact people are unlikely to be viewing the site in a static way. Council notes it is not uncommon for consent to be granted to proposals with a skyline breach under the skyline breach rule. While all applications must be assessed on their own evidence and merits, obviously, this point demonstrates that the rule is not directed at avoidance at all costs, but rather in appropriate context and circumstances, a suitably mitigated breach may be acceptable. And this is expanded upon in the evidence as well. Overall, it is submitted dwelling appropriately manages excellent rural amenity values, character, and visual effects, such that these are consistent with the district plan objectives and policies. Moving on to bulk and location effects on page 11. The section 42A report considers bulk and location effects largely along the same lines as the effects of the proposal on landscape character and visual amenity. Council proposes to do the same, adopting the same findings as above in relation to the effect of the trees and mitigating conditions on the screening of the proposal. Mr. Fowler also observes that the height of the dwelling will not be unusual in the context, and the design of the form in the form of two simple gables further reduces perceived bulk to be of an appropriate level and of low landscape effect at night. Mr. Vincent for the council does not provide the same level of architectural assessment of proposed form and does not observe the relevance of rural buildings that could occur up to 7.5 metres in height, or the anticipated height of rural buildings up to 10 metres. The revised proposal complies with all standards under Rule 4.7.6a regarding bulk and location requirements, save for the height and therefore the skyline breach. When looking at the range of contributors to yards, colours, materials, open space, and other factors, it is clear that on balance and overall the proposal is consistent with the district plan in terms of bulk and location effects. Regarding cumulative effects, in terms of the law, cumulative effects are included in the definition of an effect under Section 3 of the Act. The courts have described the concept of cumulative effects as any one incremental change as insignificant in itself, but at some point in time or space, the accumulation of significant effects, of insignificant effects, becomes significant. It is submitted here that any cumulative effects to the proposal are no more than minor in this case. The report also sets out Mr. Vincent's concerns regarding the density of the proposal and states that the area is already up to the levels anticipated by the district plan. However, Mr. Tyler's initial report dated 30th May 2024 addressed the effect, finding largely that they will be mitigated by the effective screening of the proposal, as expanded on in his evidence. In addition, Mr. Kloosterman assesses the wider experience of use of Dunstan Road and the environment which should be taken into account when assessing cumulative effect. Relying on the intentions of the Vincent Spatial Plan, he finds that it is appropriate to consider both the eastern and the western sides of Dunstan Road, including much larger spacings of the development opposite the site when assessing cumulative effects. This itself is not assessed in the Section 32A report. This is consistent with and relies upon the evidence, Mr. Tyler, that the proposal will be consistent with the existing character and the wider area. From paragraph 8.8, the plan will provide a framework to absorb built form, and all of these buildings are not visible together in any views. As a result, the additional building will not create adverse cumulative effects because collectively the surrounding buildings are all above screen. The observation is that the panel should be cautious as to considering density effects from a plan view rather than as viewed in the context on the ground in a more holistic way. The siting of the revised proposal setback further into the site, it is set back further into the site and is rotated 90 degrees from its original position. This will further assist in lessening the perception of density and built form. The applicant has heeded Mr. Vincent's suggestions in the section 42 our report as to relocating the dwelling to the rear of the site where it would have least visual prominence. Noting, of course, this is in a different location than as recommended or stated in the section 42 our report. In addition, the applicant has rotated the building to lessen the appearance of its bulk when viewed from public places. The applicants cannot address the suggestion of lowering the building height further given the needs of the particular design as set out in Mr. Williams' evidence. However, undertaking such a redesign would not necessarily have materially better landscape outcomes as addressed in Mr. Tyler's evidence, given the suitable design and quality of the building in its context. And the breaking up of gable forms to reduce bulk, which might not otherwise be achieved in a lower height building. Notably, the district plan under Rule 4.066 regarding yard setback requirements anticipates a yard of 10 metres to the adjoining property boundaries and 20 metres to a state highway. The proposal complies with these yard requirements and therefore the anticipated privacy and amenity considerations from the neighbouring properties. The revised proposal also ensures this minimum separation is achieved, and this all goes towards ensuring cumulative effects and density are appropriate. As the applicant's submission report, they accounting for this wider context, the existing pattern of vegetation and lifestyle development, and the particular development controls and viewing context, their cumulative effects on landscape character will not be more than one. And moving on, the submissions address Section 104(1)(b) of the Act, looking at objectives and policies assessment. Council adopts the findings of Mrs. Kloosterman and Tyler as to the application being consistent with the objectives and policies of the district plan. This is supported by the above comments on expert qualifications, character, and political effects. Mr. Vincent in the report concludes that the proposal is not consistent with the character anticipated by the district plans, as anticipated in those following objectives and policies. Regarding these, objective 4.33 and policy 4.2 seek to maintain the rural amenity values created by open space, landscape, natural character, and built environment values of the district's rural areas, and maintain the character of the district's hills and ranges. The core authority on the plan's intentions of the definition of maintain was addressed by the High Court's decision in the Canyon Vineyard Limited and the CODC. On appeal, the Environment Court's interpretation of maintain was challenged. The High Court judgment addresses the meaning of maintain from paragraph 101 of its judgment and includes a comprehensive review of the relevant case law. The High Court ultimately found that the weight of the recent case law supported Bendigo submissions, as summarised below. And looking specifically at the bold sections, which are slightly more important at paragraph 55, Bendigo submitted that the Environment Court did not err in its approach to the plan maintain and was entitled to grant consent to a proposal that would introduce change to the landscape. It was submitted that to maintain does not require the landscape to grow to decline and anticipates land use change in a way that can maintain the amenity. Discussing trial and QODC, The High Court's judgment reports the following. Bendigo relied on this separate case, and that case was an appeal against the grant of resource consent for subdivision of approximately 8.45 hectares in the Waikato Basin. The proposed district plan stipulated that the purpose of the subject zone was to maintain and enhance the character and amenities of the Waikato Basin, which was reflected in the proposed objectives. One of the landscape and rural amenity values at issue was the site's sense of openness. In considering the competing evidence on this point, the court held in that case in paragraph 87, at that near view scale, we find that the proposal would change the present views across open partial land limited but acceptable consent. We do not entirely accept the expert at the time's opinion that despite the additional dwellings, the site would retain a sense of openness. Rather, the contrary expert fairly observed that the proposed dwellings would sit in the middle of the site. To that extent, the proposal would render the site less open than it currently is, and as a matter of fact. However, several factors combine to satisfy us that the proposal sufficiently maintains openness in a way that is sympathetic to landform and effectively ensures the absorption of this land use change. The court then went on to proceed a list of range of factors about the site itself and the proposal that satisfied the court that openness would be sufficiently maintained, including the natural attributes, existing pattern of development, landscape plantings, restoration, and enhancement of the gully, and effective controls over buildings. And then, having considered those aspects, the court concluded overall preferring that expert's evidence in relevant respects. We find landscape and amenity effects of the proposal will be no more minor, specifically in the sense that the proposal will properly respect all relevant landscape values and at least maintain landscape and other amenity values for the gully stream and wider landscape. This conclusion was upheld on appeal to the High Court and considered by the Court of Appeal as the reason for refusing leave for a second appeal. Relying on the Todd and Bryle cases, Bendigo and the case we're discussing submitted that maintaining and or enhancing landscape character and amenity values does not require the retention of an open landscape. It was submitted that the policy framework in this case anticipates the landscape of absorbing certain adverse effects of the proposal and maintaining rural amenities. Moving on to the current matter, it is submitted that these cases, as discussed above, are consistent with Mr. Tyler and Mr. Clouston's understanding of maintain as set out in their respective readers of evidence. To maintain does not mean there is no change whatsoever, but rather that the proposal will properly respect all relevant landscape values and at least maintain them. Amenity values do not require a no change environment, rather they are highly context specific. Similarly, the policy direction under the district plan are not particularly pertinent to this application, as discussed by Mr. Clouston. Those policies have a particular direction towards protecting against adverse effects on prominent hills, ranges, and skyline views. The very minor skyline breach in this instance is not any such identified feature or landscape in those proceedings. Moving on to relevant other matters to be considered in the assessment of effects. Mr. Clouston references the anticipated intensification of the site and its context under the spatial plan. In my submission, the plan is a relevant other matter to be given weight to under relevant other factors assessment, and which is reasonably necessary to the Commission's determinations. The spatial plan is the product of extensive community consultation and expert evidentiary input. That represents a vision for future development and zoning. The fact that it signals a greater level of density for this location suggests the landscape and rural character of the area has had the capacity to absorb such a change as this required. By way of background to the spatial plan process, the Council's website states, in January 2022, the Council adopted the spatial plan, which is a visual blueprint for the next 30 years, showing what could go where and how aspects such as infrastructure, housing, and productive land use could fit together. It is a vision of what the future could look like, offering guidance as to the private and public sector, including direction for the infrastructure investment and council's future planning. In terms of the anticipated changes to the site's location, Mr. Groosterman identifies the site within the spatial plan's proposed rezoning to rural residential zoning. The explanation of the spatial plan provides relevantly that the plan identifies smaller rural residential allotments between the Atlantic and Clyde that will be connected to council's particular water supply and time. In paragraph 62, the above reinforces the submissions and evidence as to the appropriateness of the proposed value in this particular context, and the relative values of landscape character, which are more rural residential than urban natural. Given the extensive public input into the spatial plan and its clear direction for the site and surrounds, it is my submission that it should be given significant weight as a relevant other matter for consideration. Finishing discussion on the effects of the proposal there and moving on to the affected party approvals and public submissions. Judge Hassan's Division of the Environment Court has recently released its decision in Middleton Family Flood Trust and PLDC, being one of a number of formative basin rezonings that helpfully provides further guidance as to the terminology of visual amenity values and landscape character. Relevant parts of this decision explain the connection between landscape and people and how landscape character and visual amenities change and evolve over time. Applying these comments from the court to the current context, it is submitted that, as previously explored, maintain has been examined by the High Court to mean protect, which in turn requires to keep particular values safe from harm or injury. The landscape character and visual amenity values are dynamic constructs which change over time. Guidance as to what might be appropriate in maintaining landscape character and visual amenity values is assisted in the public notification submissions process. And in this instance, the initial proposal had been supported by APAs from immediate neighbours, and no submissions in opposition have been received. This signals the proposal's ability to achieve the intentions of the district plan as to landscape matter. Relevant citations from Middleton are copied below. Firstly, paragraph 176. The challenge in maintaining landscape character and maintaining core parts and visual amenity values is that environments change. Hence, both landscape character and visual amenity are dynamic constructs as part of the relationship between people and place, and changes in the perceptual and associative dimensions of landscape over time may influence how people respond to proposed changes that occur in it. Insofar as environments and landscapes change, so does the relationship of people and place. Submissions on applications can serve to help the consent authority gauge that relationship at the relevant time. Paragraph 66 of these submissions. It is noted that Mr. Vincent observed the need to obtain revised APA approvals from neighbours in the instance of the applicant submitting a revised design. Mr. Tyler has assessed the difference in effect from the proposal as advised compared to the original, which garnered APA support from the neighbours of the applicants. His conclusions are that any such change in effects will be negligible. It is therefore submitted that the Commission may make its assessment based upon the evidence before it as to effects of the proposal and conclude that the effects of the neighbours are less than minor and are appropriately granted. Should the matter of concern for neighbour effects be something likely to tip the balance of the Commission's decision, the applicant seeks to oblige this by way of written reply. In conclusion, for these submissions overall, given all of the above, the applicant submits that the application is revised with a further detailed assessment supplied in the evidence, will maintain rural amenity values and landscape character in accordance with the objectives in the district plan. Effects on landscape character and visual amenity from the bulk and minor skyline breach of the proposal are not more minor and are appropriate in the context. the effects of the application will not be written on it, and the resulting form and density is consistent with that anticipated under the Vincent spatial plan. The application is consistent with the objectives and policies of the district plan overall, including those policies as stated. And lastly, the application should be approved and according to the proposed provisions to be discussed in the evidence of Mr. Houston. Unless the commissioners have any further questions to add, that includes my submission. Pass to the experts to comment.
Thank you, Mr. Russell. Just got a couple of things to clarify that I think probably fit into yours as opposed to the experts. And in particular, Mr. Ploosman might pick this up later on, so that's why I'm asking you, so you can think about it if he needs to. You talk about the Vincent spatial plan, and how that's relevant enough to be given weight to. But isn't there a heck of a lot of work to be done to actually implement that illustration? Yet, it's going to go through quite a rigorous process to develop into plan changes and those sort of things. So while it could have performed, it's still actually not necessarily the final outcome. And some might say could be very far from it.
I understand what you're saying. This would probably be more assessed and to do with Mr. Ploosman's evidence. And he'd probably be more up to date on exactly how much there is to go than me. But I understand what you're saying.
Yeah.
I might have to ask it to Mr.
Yeah, no, I thought you might, but I thought if I flag it with you and see what you thought, I think you were saying, well, I think you just said to me, yes, no, maybe, but he'll tell me.
Yeah.
Because that's what I was hoping, because I'm going. And the other thing that I might have missed something really major here, but the change in the site and the rotation,
Yeah.
where did that come from and where's it at? The only place I've seen it is in Mr. Tyler's evidence.
Yeah.
I didn't see it in Mr. Ploosman's. So I'd be very interested when it gets to Mr. Ploosman about saying, well, does that change anything that's in your evidence? Because I wonder if you might have said different things. So I just want to make sure I didn't miss something.
Well, as I understand, there is the 90-degree
Mhm.
horizon and further
14 metres back, yeah.
There's still the skyline bridge and
Yeah.
obviously the height bridge still with the albeit to a more minor level than it was originally proposed. But yeah, it's been further assessed in the evidence. So
Importantly, I did read it in the right place and I didn't miss something. I was just sort of surprised that when I read Mr. Ploosman's, which I read first, and then I got to, I missed that. What happened there?
yeah, no, I think the proposed effects will see that in this evidence. So along with the visual simulations as well, which will more effectively show the size of the proposal than the height poles which we did.
And I'm not sure I got all the references to what happened in the Canyon versus the council and Bendigo. But just to make sure I've got it right, I think is that Bendigo had a consent that was granted and Canyon appealed.
Yeah, and it was appealed and then attempted to appeal to the court.
Yeah.
Yeah.
And the upshot was, I think, the last bit I picked up, the bit that struck me as being probably the most important is that it was a lot of it was about the interpretation of maintain.
Yeah.
And which I think in your paragraph 64, I don't think I know, because you said maintain has been examined by the High Court to mean protect, which in turn requires to keep particular values safe from harm or injury. Yeah, all the other stuff didn't help me one little bit, but that did.
So I'm grateful that the paragraph at the end was summarised as something.
Yeah, yeah. And I was involved in the decision, so I was even a bit more confused because it was quite a tangled web with they appealed to each other, didn't they, from memory?
Yeah, councils.
Yeah.
Yeah. I will note that it's a different site.
Yes, yes, quite different. That's all right. So, but yeah, because I think what I read, what I thought I heard you say prior to that paragraph was that protect doesn't, maintain doesn't mean protect, and then you kind of come out different with your summation. So I obviously wasn't following it very well, but yeah.
Paragraph.
Yeah, thank you.
Keeping something like this.
Right, okay, I'm not going to go down any other legal rabbit holes because I'll get myself caught out in Martin.
I did hand a copy of the summaries.
Yes, yeah.
There were 10 copies in the
Yep, no, we got them all.
Do you want some copies?
Yeah, do you have the copies this morning?
You-
I think the point of
Yeah,
clarification is-
just while we're getting that, just a point of clarification from Anne, I failed to, sorry, I apologise, I failed to actually introduce everybody, I normally do. Before I ask everybody to introduce themselves, so I might just do it now, anyway. Obviously,
We introduce ourselves.
yeah, and I usually then say then that and tell you who we are, but I didn't do it for some reason, I was excited and wanted to get on with it. So I'm Neil Gillespie, I'm the chair of the hearings panel, obviously Martin McPherson is, a panel member along with Councillor Ian Kearney. And Anne Rogers is our advisor to the panel from a planning point of view to make sure we keep on a straight and narrow. Karen looks after all the admin stuff, and of course, you know, Adam is the Section 42A report writer. So Anne, that clarification that I'm going to ask on your behalf.
Yeah, so just to Chair, in terms of the amended site plan, am I correct that that came through in evidence on the 2nd of December last Tuesday?
Yes.
So in terms of the profile poles, they don't reflect the amended, are they still up?
We've just had word this morning that the profile photos have been put up in line with the amended proposal.
Okay,
So they are there if the commission's wants to the site visit.
Okay.
Yeah, I think, yeah, because I stopped there this morning on the way in and I didn't actually notice them. So figured they were down, but
Yeah.
that might reflect that they're now 14 metres back from where they would have been otherwise.
pretty tight.
Yeah, the applicant's builder has put them up.
Okay.
And just by email, Ross went this morning and said they're all up correctly.
And-
I'm assessing myself.
Okay, and I guess one more clarification that the affected parties haven't been privy to the shift in location. Is that
Yeah,
correct?
I did touch on that in.
Yeah,
Just quickly,
Yeah.
yeah, so they gave original APAs.
Yeah.
And have not received them yet for the current proposal.
Okay, so you're still
So,
waiting for
yeah,
those?
yeah, if needed
Because
though,
the shift might
yeah.
more
It is.
result might be experienced by the
They go
neighbours.
slightly closer to the neighbour at the rear of the site. Yeah, as I said, I've been trying to get those and needed. If the decision with the engineer or anything like that.
Okay,
Right.
thank you.
Good to thank you for that. Right, you can go to who's next. And bearing in mind, we do have the evidence, we've got the summaries, and I'm sure that the experts will don't need to read it. Well, they may or may not need to read everything. I'll tell us what we need to know.
But if you have any questions for Mr. Williams first, as the with the evidence for the applicant, for evidence of the build design. Exit the site, and that might assist. That's
Yep. Thank you,
the
Mr. Wi-
reasons for them.
Yeah.
And set out.
Yeah, and as I said out, but if Mr. Williams has anything he wants to sort of say by way of a summary, it would be helpful rather than just me just give him a cold call question. He may want to impart on us the key points of what he's trying to achieve.
I think it's quite set out in the evidence submission.
I can only really repeat what is in the evidence. I am very much a layman, so
Yeah.
I think the crux of the matters are matters that are beyond my ability to comment. I mean, I was simply trying to create a refuge for my wife that she would be proud of, would be comfortable in, and would encourage her to continue a number of activities whilst her condition deteriorates. The idea of, I mean, the proposed building is a barn.
Mm.
That's all it is. So, perhaps the only other thing I can say is that when my daughter was looking to relocate to Alexandra, she looked at a number of properties. And the motivating factor for her to buy 353 Dunstan Road was because of the abundance of vegetation, trees, shrubs. And it is certainly her desire that that be maintained and continued.
Thank you. I think that, you probably summed it up. It's, what you're trying to achieve is quite simple and straightforward. Someone's got a lot of rules and regulations in the way that make things a little bit more problematic than what we probably all generally like. So, thank you for clarifying that, and it was pretty clear from your evidence as well. So I've got no particular questions. I think, as you said, Mr. Russell's well set out on the panel. Anybody else? No. Thank you.
Thank you, Commissioner. Next to flash. I think it's the summary statement, which.
Yep.
Hello everyone, and I take it that the full copy of my evidence has been read and reviewed, and everyone can look at the material. So I'm Richard Tyler, my qualifications are set out in the statement of evidence. My evidence has been prepared on behalf of the applicant, Natasha Williams, regarding RC 240033, the second dwelling. The site, as you know, is within the rural residential zone, the northeastern side of Dunstan Road. It runs northeast to southeast parallel to Clyde Alexander Road. And the area is flat, slightly sloping, up from Dunstan Road up towards the elevated terrace, north of the site. I undertook an initial site visit in May 2024 for the initial application. And during the site visit, the 8.2 metre poles were not up, so only the lower poles, the smaller gables were up. The site has a significant number of trees, which meant that at that point in time, even if the 8.2 metre poles were up, I was not able to see clearly from the road or easily discern a potential skyline intrusion. The river terrace beyond was hard to make out through the foliage, which exists beyond the site and within sight. And I noted at the time that existing vegetation would provide enough screening, even if there were a skyline breach. But at the time, not knowing how significant that was because of the poles moved up. I noted views from Dunstan Road were short and filtered, but I did not assess from the nearby trail. This made a sort of an incorrect presumption that they were similar. My resulting recommended condition in the report is that 75% of the trees along the frontage, the road frontage, should be retained to maintain screening from the road. But I know this condition has not been picked up in the section 42A report of the resin. The surrounding rural residential zone has been subdivided on the north side. It's existing vineyards on the south of Dunstan Road. Landscape character is made of seasonal screening trees surrounding properties on the northern side. The more open productive vineyards on the south, and the elevated river terrace which lies to the north, which I do note is also reasonably difficult to discern from this point of the road. And the Otago Central Rail Trail, which includes recreational and aesthetic values for use of that trail. Following concerns raised by Mr. Vincent in the section 42A report, the proposal has been amended, as we've already noted, to be 90 degrees and have an increased setback from the road. This is the added advantage of a larger perceived setback alongside the road, a landscape setback, which I do note, which should only view when the trees are not in leaf in the winter. Otherwise, obviously the trees become, the immediate context where you're driving along the road. And we have now had an updated landscape plan to preserve the existing trees for seasonal screening. So I further assessed views 1 to 5, which are appended, and they demonstrate the visibility of the initial and revised proposal. Now, just mentioning that I felt I should do this because obviously with the trees in place, it's very difficult to see what's actually going on. And in actual fact, when I look at them now, they do appear probably worse than in reality, just because I'm sort of showing what's happening if those trees don't exist. But then it gives everyone a good understanding of the scale and form of everything. Because per se, if there's no trees inside. So that they're a useful tool to understand the extent of the skyline breach with no trees in place, or in winter when views are more exposed into the site. Montages provide a more accurate demonstration of potential effects rather than just relying on static photos. I confirmed montages are based on the actual and corrected heights of the proposed dwelling, which is now 8.792 metres from the existing ground level at the southern end of the large gable and 5.559 metres for the smaller gable. And I just note that I've taken that to be the front of the building at the end facing the road, and at the back of the site, I anticipate there'll be a scrape out of approximately half a metre, which will reduce the skyline, the height bridge further back. In the summer, the site is well screened from outside the site, and in the winter, visibility remains softened and appropriate in the context of surrounding deciduous trees, the building form and location mitigating any potential effects. So I'll just do a quick summary if that helps everyone. So from Dunstan Road, there is now minor or what I can see to be imperceptible skyline reaches. In particular, when driving past at 80 kilometres per hour and viewing obliquely into the street. From the rail trail, people will be viewing at slower speeds. And from here, it's slightly elevated and further back from the site. So there's, I anticipate very low visual effects due to the design and the setback, and the building now sits under the skyline with no bridge. And actually just noting that with the initial proposal from the rail trail, it didn't breach either. I'll just double check that. Yeah, right. So views from neighbours, from the southern end of dwellings number 347, which is the lot to the north, directly to the north. And you can see that on appendix A. Now that lot's 1.5 hectares in site. So the initial proposal had proposed dwelling 59 metres away from the southern end of the rear dwelling. The revised proposal is now 47 metres with the building rotated. So overall, the viewing distance is slightly less, and with reduced bulk, the proposal will have a very low effect for the views in comparison to the initial proposal. For the site to the east, it's number 339, and that's 1.7 hectares. Their dwelling is located on the southeastern side of their lot. They have an open field on the northwestern side, and then a row of Maricarpa pine trees that run along the northwestern boundary. So the revised dwelling will remain 95 metres away at the same distance from the dwelling, with a significant amount of large evergreen screening trees running along their site and along the neighbouring driveway. So it's unlikely that both these trees may get removed. If they did, open view of dwelling at 95 metres sit low on the skyline and have a very low effect on the views. Compared with the initial proposal, the revised building may have a slightly larger bulk from here because Gavin will now be running laterally for them. But I'd say, given the long viewing distance and immediate screening trees, which are unlikely to be removed, any effect arising from the change to be very low at most. So the design includes two single gables, which further reduces perceived bulk, and is appropriate height, quite large, built form in the rural area. Dwelling sign will appear similar to a rural barn in approximate rural residential landscape character. In addition, the following factors will maintain rural character: the existing vegetation, maintaining screening and privacy, the existing dwelling on the site is well screened, no visible increase in density from key public viewpoints. And when viewed collectively, the surrounding dwellings along this side of Dunstan Road are well screened from the road. The proposed dwelling will not form a notable increase that will hit the threshold of adverse cumulative events. And I note on this point, it would be quite different if the site was an open, exposed landscape. It would be a different landscape context. This might be a different. They might make a different cumulative summary from that sort of landscape. So the proposal aligns with the relevant objectives and policies of the district plan. Notably, it will maintain rural amenity, open space, and landscape character, avoid undue prominence and built form, minimise adverse effects on visual and landscape values, result in very low adverse effects on visual and landscape values, and appropriately manage cumulative effects to revise design and landscape. If the proposal is approved, landscape plan be included in the suite of approved plans. That's the summary.
Thank you, Mr. Tyler. Just was speaking on the height down of things, so you have confirmed that the montage that you've used 8.792 metres is the highest point of any building above existing ground level.
Correct. Yeah.
Does that include the chimney?
I didn't include the chimney. So the chimney's over and above that.
Go to your photographs. So those photos you took with the montage on were in August, which is
On the section 42 area.
Correct, yeah.
the ones that
And I anticipate, nothing's changed, let's see.
you're right. Very similar, despite the fact that we're supposedly in summer. And the original ones you had were based on May. Okay, cool.
Yeah, slightly more autumnal, but there were still leaves.
Yeah. That's good, thank you. I'm interested in the neighbour at 347. And I guess that you're saying that in spite of the fact that the building is now 14 metres closer to them, because of the 90-degree rotation, the bulk they're looking at is quite different. And are you saying basically those two make up for each other or makes it better
Well, I think,
or less?
distance, even if we're similar, it's just that the amount of distance change in that entire length is hard to notice. And in fact, yeah, I think bulk will help reduce, the rotation will help reduce that horizontal gable.
Yeah. Okay, so I guess, yeah.
They will see it, I suppose, coming up their driveway, but this, I generally perceive that the view from the house is the most important location.
Yeah. And I suspect that their view on that view might be quite important. I suspect we haven't got that at this stage, which is not a criticism,
Yeah.
but I think it's going to be something that will be important to understand.
And just noting as well, against pine trees along northern
Boundary, yes.
boundary, yeah.
Yeah.
So, I mean, the views through those trees, as long as they're maintained, will be very much filtered. And I believe that they evergreen trees, the ones that back. Yeah, so that's not affected.
Pick that up from the map. Thank you. No, I think that you've picked up the different things that I was interested in. Martin, Oscar, concerns. Ian?
Small point of clarification.
Thank you.
If that's okay. Do we have a full suite of scales? Like of the revised proposal in terms of site plans and
Building designs.
well, not full designs, but just a full suite of scales plans for the house and the site. We seem to have a bit of a mixture.
Yeah, as that, on the evidence it's filed, the Tyler at least, there's the actual site layout plan.
And they're to scale,
Yes, yeah, that they are, yeah.
so that is it figure 2 and your substantive evidence can be relied upon in terms of the location of the
I'll
design?
double check this scale because I think I have to say sometimes
Because I see it's up to 500 of A3, so.
Yeah, but that
Which is the same scale as figure one, which.
Yeah. Yeah, in actual fact, I do have to admit that figure one is incorrect, so that's, I think. No, that was, so ignore figure one scale, that is in fact,
So that's the site plan we've
yeah,
got.
sorry, that's a mistake, so figure two is correct, the scale of figure two, yeah.
Okay.
So, is there anything you would like me to measure, please?
No, I just wanted to make sure that we had an accurate set
Yeah.
of plans if the panel were of a mind. Yeah,
All right, so let's make sure appendix A, figure, oh, not
so
appendix,
figure one.
figure one of appendix A is not to scale.
Yeah.
That's what's wrong with it, just not to scale,
Yeah, it just wasn't quite,
Yeah.
wasn't quite. there.
whereas figure two
No, that is a confusing.
is to scale.
Okay.
Where did you put that up?
So, sorry, one more point of clarification, if I may.
Please do.
So the photo montages, are they based on, I know they're based on the photographs, but are they, like, can we rely on them in terms of whether or not they're based on figure one or figure two?
They will.
They look awfully close, is what
Yeah.
I'm saying. The montages have them looking awfully close to Dunstan Road, given that it's
Yeah.
a 40 odd metres.
So, no, that's correct. So the scale of the plans does not relate to the photo montages, and they're separate, inherently separate things. The photo montages are accurate, and I've checked them a couple of times. But the reason they appear close is the way I do my photo montages is that's the way that the Institute tells us we should be doing them, is that if you hold this up 30 centimetres from your eye, that is the exact same scale as reality. So, so in fact, if you're looking at these pages at a full arm's reach, it will appear larger than real life. But the main thing is, you know, that in fact, if you hold it 30 centimetres from your face, that's pretty much what it's going to look like.
I will note clarity, that's as printed at A3.
That's correct, yeah, printed at A3. I'm probably not the best having to put this thing up in your face.
I suspect that A4, it looks bigger.
It looks bigger. And in actual fact,
I have one more
Correct.
question.
it's an interesting point because
Orientation as well, because that appears to run in the original. Or is that what's the ice plane fixing? The orientation of this montage seems to run in the same direction as the original proposal, rather than the gable
So if you
facing
look,
that.
if you look at the page, the next one, that shows the revised proposal. So it's, so for instance, figure 1A is the initial proposal, and then if you figure 1B, it's the,
Revised.
it's revised one, yeah.
Oh,
So what I was trying to demonstrate is the way it's improved.
Yeah.
okay, all right, thank you for that.
And does the angle the photograph's taken at have any difference on that?
Well, so what I do is essentially when you're talking about the angle of the photograph, everything that's in the photo is being matched with a real feature on the photo. So
Okay. Yep.
you can see the sort of faint lines. I did it pretty roughly for this exercise. I'm not going environmental or anything, but it's good enough for us to understand it. But you see the fence lines which I mapped. So in view 1A, you can see that in the foreground there's the road and fence lines. So we sort of line everything up so it's
okay.
Crocodile over the top.
That answers my question, because I want to know what those little lines were on the top.
Yeah.
Yeah, thank you.
Okay.
Yeah, and normally what you do is you want to have the centre of the subject in the centre of the photo. So that's generally how you line up the view.
And the argument for reducing, no. Now the building's been rotated through 90 degrees, you're saying that then reduces the perception of the bulk of the finished structure.
Well, yes, correct.
Yeah.
Wind view from the road from that side. Yeah.
I think it'd be interesting to see what the neighbours have to say about that. I think you guys
And I like that the professional can take photos and get a shadow in them. Means that my photos aren't too bad either. Yeah. Wasn't a criticism, just that.
It makes it feel better as a photographer.
And an iPhone 13 Pro is the go. That's, yeah.
Well, I mean, just interesting, a lot of landscape architects use SLR cameras.
Yeah.
Stuff, but as long as you tell people what you're using and it represents reality, it doesn't actually matter. Really.
Just recall a lesson or two I've had from other landscape architects about the need for the right camera with the right lens and.
Yeah, I don't necessarily follow that. So,
On their own question, Mr. Williams can make a quick comment about thank you from the neighbours.
Yep, that would be interesting.
Yeah, it's just to give you some idea. I've come to know the neighbours, Mr. and Mrs. McGregor, quite well over the last couple of years. They are, I think, somewhat bemused by the process. And they really have no objections one way or another. They are Otago born and bred of a certain age, and take a rather, as long as he's got enough land to practice his golf putts, he's happy. They do, however, travel quite a lot, so just nailing them down can take some time.
Yeah. I appreciate that. Thank you. And that's not an uncommon response to hear. But I guess for us, the important thing is to make sure that not that we don't believe you, but some people have thought that's what they thought they've been told, and the person says something different, and it's going, ooh, yeah, they were too polite to tell you what they really think.
I
don't know.
fit that category.
Yeah. No, thank you for that. Right, you've clarified, Anne, all you need.
Clarified, thank you.
I am too. Panel's happy. And did you need any clarification, anything, Adam, or are you going to pick it up later on? Rather than go back to it, might as well deal with it.
Thing for mine, Mr. Chair, just around the training condition we had in the original, was that along the entire, sorry.
Yes, it was. And yeah, I probably didn't put enough time into thinking about what that would look like, but it was generally just to say, look, let's retain trees along the road. Reviews and
I guess the idea would be the X number of trees there at the moment, 75% they could remove Y number of trees, which is like they could remove 25% of that number of trees. That kind of things.
Yeah, and I suppose the way I looked at it is there was enough trees, around generally that if you did remove one or two, it's not going to break the bank. You'd still get the majority of the views would be screened. You might get a few glimpse. But I think as with the revised application and chatting to the applicant further, they're quite happy to keep all of them if they have to.
Thank you. Thank you, Mr. Tyler. And that's it.
Mr. Kilson, and Sticks.
Thank you.
Good morning, Mr. Mayor.
Councillor.
The actual application has been very thoroughly canvassed already, so I'll speak to two things which will come up in the context of what has been discussed at this stage. So in relation to the spatial plan and district plan, the relationship between the two. The spatial plan is not the district plan, it has to go through the first schedule process, which has its own rigors. So it cannot be used now in lieu of the district plan, we know this, but it clearly indicates council's intent for this area. So we're looking at a density of development based on the current district plan. Council has clearly defined what it intends for this area. And I don't know the timeline on the plan change to put that in place. It may be 18 months, 24 months. But if we were sitting here in 24 months, that whole issue would be potentially to one side. So it's all a matter of time. The spatial plans have been used in Central Otago District Council decisions previously, and refer specifically to the Cromwell spatial plan and application to put a residential development between the Western Orchard and a car track. And the spatial plan was heavily referred to in that decision. In declining that application, because it just was total discordant with the spatial plan. So although not actually say not codified into the district plan, it had a huge amount of weighting on that decision. In relation to the application and why the original application has the dwelling in a different place in a different alignment, the modified application was in response to the Section 42A report and an attempt to reduce the quantum of effects for the entire development. So that's why so we had a certain timeline to make this all happen and get it back to the council within 10 working days, 5 working days. So that's why my evidence did not refer to the modified application. One slight upside of the modified application is in relation to the chimney, which in the original application sat broadside to the road, and so it was more visually prominent. And the chimney is counted in the context of total height because it's over 750 mil wide. It's a critical measure. But from the perception from the road of that chimney, there's going to be basically it's going to be substantially less because of the 90-degree rotation. That's something for the council to consider. In regard to cumulative effects, cumulative effect is this idea of the straw that breaks the camel's back. You know, how much is too much? When can we hit a critical mass? So there's 3 cumulative effects to look at in relation to this particular application. The first is in relation to density. You know, what does the district plan currently anticipate number of dwellings per hectare? And the Q comes from the minimum lot size, which whereby things proceed without the need for a resource consent or something, a discretionary or higher resource consent. So for density, the assessment was made by the reporting planner based on, I assume, on certain proximity and within on one side of the road. Directly across the road from the development is the Ruru Vineyard, which is also zone rural residential and within which there is one dwelling that I'm aware of. So, which is back further towards Alexandria, the schist stone building and winery. So, if you take, let's say, if you encircle the proposed dwelling location, and then look at number of dwellings per hectare within a certain circle area, I don't think the cumulative effects in this location we haven't hit critical mass in terms of dwellings per hectare. In terms of cumulative effect of skyline breaches along Dunstan Road, potentially this may be the only one without having done a comprehensive review. So how many skyline breaches occurring in that area, you know, over and above that skyline? And I don't think there are many. So the cumulative effect of skyline breaches in this location is not, I don't think it's a relevant factor. In terms of height exceedance, the cumulative effect of too many overheight buildings in this area or in this location. And again, I do not think there are many, mostly those single-story dwellings along Dunstan Road. So it's we haven't hit the same critical mass in terms of where it becomes too much for the council to contemplate another one occurring. So that's just, that's a very fundamental point raised in the context of hearing so far. People taking questions.
Yeah. At the risk of observing something that Mr. Vincent may well raise, and it relates to timing. So that the panel agreed to a longer time for the applicant to bring the evidence through. And I noted your paragraph 8 in your summary that we've chosen not to commission a peer review. I'd be interested to hear from Mr. Vincent. He'll cover it off, I'm sure, but the timing of what we had to do that from when we got the most recent landscape evidence probably made it a little bit problematic at this stage. I suspect.
My correspondence with Mr. Vincent in relation to a peer review was at section 95 report. So long before section 40.
Yeah. But I guess what I'm saying is that because of the changes that have come through in the evidence of the change in location, the different photo montages, is the opportunity for council or for the reporting officer to have maybe consider whether a peer review was required or not. May have or may not have crossed his mind. I don't know. We're going to find out. Yeah. I'm just making sure he does. And I'm saying is that, timeframes got compressed, and it may well be that opportunity, I understand 695 wasn't chosen then, but may have been picked up as something that could be picked up for now. But I'll be interested to hear what is said in that respect. But just that you raised it in your summary, so I thought I'd just mention that to flag it.
The application was provided with a landscape report. And based on the modified application, Richard has prepared these photo montages and as a professional in the field, it's confirmed that the effects are still no movement minor. Sorry, not like words, but
yeah.
So
and the panel may have a view that says to the reporting officer, well, maybe you should have got a peer review done. Because no, that's what I'm saying. That's just saying what we might think or not.
Yeah.
I've got no other questions. Thanks, Mr. Clisman, panel. Clarifications?
Please.
I thought you might.
Through the chair, points of clarification. So the reference to residential development that you made, Mr. President, and on way between the orchard and the racetrack, is that plan change 13 we're talking about?
there was a development, Queensland development, I do not know the plan change number.
Winton Partnerships,
Right.
review teams. Okay, it was the plan change.
60 and change 60.
13.
13.
Plan change 13, yeah. So it wasn't a resource consent, it was a plan change. Yeah, yeah, it's okay, I'm just clarifying.
Yes.
We didn't hear that.
No, it's an independent commission.
Panel, yeah.
Sure. One, I guess another, kind of, one of my, how high is the chimney? I can't see. And also the scaled elevations, can they, in the application, are they to scale? Can we rely on them in terms of?
In the application,
Yeah.
yeah.
So they've remained unchanged, the scaled elevations.
So probably if that's printed like 4, generally this would be A3 plan to that. So maybe not. There was, I saw a copy here, so it says scale 1 to 100. Normally you try and say at A3, but I presume that was A3. So yeah, probably not.
No,
But
I suspected not. I just
at A3, then
concerned that the panel, it would be good for the panel to be able to be working with a true set of scaled plans and elevations. That's my points of clarification.
If I may, a little bit, I think on page 142A, with the original plans, I mentioned it's our, so. Should like.
Sounds about right. Yeah.
So just to clarify then, take that one step back, that's half a metre on top of the height that Mr. Tyler goes.
That's correct.
Yeah.
I'd say so, man.
But I think what I did here was that the change in the angle of the chimney does reduce the bulk in terms of for the height.
Yes, it's, because of the 90-degree rotation, you're looking at, say, at the thin side of the chimney, rather than the broad side.
Thank you.
Right, thank you for the applicant. And anything else you want to add before I pass over to our?
Nothing else at this stage. Comment on the APAs to be made.
Yeah.
Back to you.
Thank you. Right, ask that the planning officer talk your report, please.
Thank you, Mr. Chair. To start, I just wanted to comment briefly on the future circulation, peer reviews, lack thereof, what Tyler were, and I guess the decision to work through the decisions that I made when I was assessing the application for my topic report and why I didn't get a peer review at that time. Essentially, and this is potentially being the time, I didn't think it was worth time and money being peer review at that point because the evidence he provided was fundamentally flawed. So I don't think we've had landscape evidence that's actually been worth peer reviewing until 5 days before the hearing. I do know, I don't know off the top of my head if the particular correspondence made it into the agenda, but I did, like, in my 95 report, I outlined why I was disregarding Mr. Tyler's evidence that was provided. And before I started drafting the entire report, I gave the applicant 5 Mr. Person an opportunity to update that information. And the advice that I've got was that they wouldn't be doing that given their no submissions. Hence why in my full entire report, I had essentially disregarded Mr. Tyler's evidence. Does that clarify?
Yeah, yep.
Looking at the evidence we have for the candidates in front of it now. Broadly speaking, it looks like it can be relied on. Obviously, if the panel thinks that a period is appropriate, then within the card out support. But I'll give my thoughts today based on Mr. Tyler's evidence, noting that I don't have qualifications in landscape architecture. I've got qualifications in planning and graduate diploma in law. Not that's particularly relevant today. So obviously, in lieu of any other evidence, I'd be deferred to Mr. Tyler. Briefly on one point briefly Mr. Clifton's evidence around cumulative effects and skyline breaches in the area. I'm also I'm not aware of any other dwellings along that side of the road that breach the skyline, but I'm also not aware of any other dwellings that breach that exceed 7.5 metres in height. And my assessment based on observations on the site, I didn't see any reason why a 7.5 metre tall building would breach the skyline. I mean, it seems to be, but the breach of the skyline seems to be a result of the height of the building exceeding 476 as well. Also, yeah, Mr. Chair, you see the papers of Mr. Russell, the states that Mr. Tyler says the height of burden would not be unusual in this context. To my knowledge, and I haven't had the chance to have a very good look through our records, this will be the tallest residential building in the district. And in the top percentiles of tallest buildings also in the district. In a rural context where the app is correct that you could have 10 metre high farm sheds or rural, like building associated with rural production. But typically we found buildings have been like lower than that. Typically they've been single story, particularly dwellings, particularly in that area. Most guys are single story. I think one of the exceptions is on the Ruru vineyards, which I'm sure how familiar the commissioners are with that particular dwelling. But it's on the opposite side of Dunstan Rose, plaster and schist. And that is 5.9 metres high. So this dwelling you're adding half a metre, essentially, to the pressure I jump around a little bit. It's just a little bit of preparation for how we have this information. In relation to applying for the baseline, there's no permitted building that can be built to that scale in the application, because any building to that scale in the application reaches for 476 designated, reaches the skyline. I think for that reason alone, notwithstanding that a taller building could be built elsewhere, paper, this specific application, for that reason why I think it would be not particularly useful to apply any other building in any other location as a permitted basin to this proposal.
Can you just rerun through that? The permitted baseline is a 7.5 metre residential.
There's no permitted residential buildings because any residential building is consent.
So the standard
The applicants, yeah, the activity standards
7.5
is 7.5
and 10 for
10. So you could have a permitted farm shed or similar that was 10 metres high,
Yeah.
provided it didn't breach the skyline. Which is one of the other, like the skyline said, it's one of the other permitted activity. And given that a building to the side is on that side breaches the skyline, I don't see why it's a useful comparison to say that a building could be built elsewhere with a similar scale. That's the effects of my mind up to the fair enough.
Yeah, I'll let you go with the other stuff and I'll come back, I think, to that when you're finished.
The other main points in contention are rural character effects to my mind. With rural character, I completely agree that maintain doesn't necessarily mean set in stone, keep exactly the same. Indeed, the plan does allow for changes, land use changes that some would argue may have notable effects on landscape characters. Example comes to mind with the conversion of a large area of pastoral land to horticulture. For example, possibly from the particular expertise, but that type of land use change is permitted, that would arguably have an effect on the landscape. So completely agree that the district plan doesn't anticipate set in stone. However, the district plan still directs decision makers to have regard to retaining what it does it maintain what the district planning anticipation rule character to be? We see that set out in objective 4.3.3, which is it gives general broad strokes of what it is that that will character be. Defined with having like areas where having open space, natural character, and particular built environment values. I interpret that to be built environment, particularly being relatively spaced out and at relatively low densities. As I've noted, the proposal does increase the density beyond what might be anticipated. So using the example of the land to be subdivided and you would have to have two lots into the house now would be in breach of the 2 hectare standard for subdivision. So at a point where where that anticipated density, if you were to be fully compliant with the district plan, is being breached. In relation to cumulative effects, just to clarify, I was looking at specifically at the lots along the northeastern side of Dunstan Road, so the same side as the application site between Waldron Road and Crouch Road. I didn't give any weighting to Ruru, which is a much larger lot. It's around 19 hectares. Yeah, that's what it's like.
18.995.
Not 19, 18 hectares. On the basis that it's as a controlled activity that could be subdivided down to 2 hectares. So I don't see why the applicant should benefit from the fact that the owners of the abandoned haven't yet opted to undertake a subdivision to council. I'm happy to finish up talking about the conditions that what I think this person might generally in agreement around the conditions that should be imposed if panels are not over underground consent. With the with this person of proposed condition 3, I think particularly given the point of this Roger raised around council making sure we've got forces of to scale plans to refer to. Condition 3, one amended condition 1 should probably be referencing either those specific plans or evidence actions and appendix, as opposed to just referencing the plans lodged in the aerial evidence personally. Particularly, we would be relying on sets of plans that were developed at different times. Because my assumption would be we'd have the amended site plan, but use the dwelling plans that were provided with the original application. And with this was might be more efficient for us to question, but you haven't given a specific, there's no specific wording that's been proposed for the actual condition. You can perhaps on their own regard, if you want to get a draft of that in your slide.
Through you, Mr. Chairman. Processing.
We're not,
Right.
I promise you.
That's in relation to the landscape condition or which one?
Yeah, condition 4.
Yes,
Yeah.
okay, I provided suggested wording to that on your last time that we were
Summary. Okay. I guess it's slightly different. Mr. Tyler.
The application will be subject to a landscape plan which will be lodged with council and prepared a landscape map for especially what you've got in front of you here. And the expectation would be that those trees would be retained. Or if in the event that they died or natural attrition or whatever it was, that they would be replaced.
So that's not what straight on my heels. There would be similar to the plan that's provided, that's been provided with this tile evidence, as opposed to saying any trees within 50 metres of the state highway, of the Dawson, sorry, which I think is what Mr. Tyler originally was.
My expectation would be they would be nominated trees. Some of the trees, any tree within 50 metres, potentially trees which are not screening. So they're not too relevant to the relation.
So the experience, so it's essentially it's a plan that hasn't been provided to you, but will provided it.
I have seen them say condition of consent, landscape plan shall be lodged to the satisfaction of council.
Which comes with generally only, but if we're satisfied that landscape plan principle will be done.
Yes.
So it's
That's the factor.
okay. And that covers off the things I immediately wanted to talk through. There's been a lot of that's probably a few things I missed, but
I suppose the important one, and Adam, is your recommendation, does it remain the same?
I think on the whole, my recommendation remains the same. Fundamentally, I'm really struggling to reconcile in my head why council should be allowing both a breach of the height standard and a breach of the skyline at the same time. I'd personally be much more comfortable if either one of those was exploited as a way of more appropriately managing how this proposal affects the rural character of the area, the rural residential character of the area.
Thank you. So just to make sure I summarise what you just last said, is saying basically your recommendation is to remain the same, and your logic, the logic you're using is to ensure the rural character of the area is maintained. Is that summarised correctly? Thank you. So just one thing I want to just check about the permitted baseline side of things is that you're saying that the standard says maximum height for residential building in this zone is 7.5 metres, and that a rural type building farm not farm, but non-residential building up to 10 metres is a standard that's permitted. And what we've got here is that this is not a rural building. Yeah. And while I think I've heard from the applicant that we are able to consider the effects of those two activities as part of a permitted baseline way of looking at things, you're saying we can't or we shouldn't?
I'm saying that I would say that you can't, on the basis of permitted building, could not be built in that location to the scale that's proposed, on the basis that that building will also be breaching the skyline. I don't think it's useful to compare the similar building in a different location, because they, like, the similar building in a different location doesn't reach the skyline. Because that will get a different context. So those effects aren't really similar.
On a moment while, sorry, I'm just trying to check what Mr. Russell said in his brief about the permitted baseline. Got 5.
Okay.
Go back one more. So Mr. Vincent, can I take you to a submission from Mr. Russell to paragraph 18? And I guess in paragraph 18, Mr. Russell detailed the suggested questions from the Environment Court. And I'd be interested just for you to run through those 4 particular items in there and tell me why you are of the view that you're of in line with those questions, or how they might help me understand.
I think the most, so the point in that framework that I'm essentially getting at on most of point 3 around whether it's useful for comparison. Because I don't disagree that a 10-metre high rural building could be built to the right and but I would be very cautious about taking a 10-metre high building in a different context and saying that because a 10-metre building could be built in a different area, you should just disregard the effects of the 10-metre high building over the permitted building. On that site, an application permitted building would be lower than what's proposed.
Because of the skyline.
Because of the skyline.
So it wouldn't
When you're looking at those, like when you're looking to disregard effects of permitted activity, I think you do need to look in that wider context of can what that proposal actually does for permitted activity in the end, as opposed to elsewhere.
Yeah.
If you can't, like if you can only do it elsewhere, is that the useful comparison because you're not looking at an application in the same context?
So only could a 10-metre high building with that site be built if it didn't breach the skyline?
Correct.
No, yeah, okay. So the fact that one's a rural building and one's a residential building, is that a factor as well? Because the permitted baseline doesn't provide for this building to meet that criteria because it's exceeds the height requirements. So it doesn't meet the standard.
And any residential activity, any residential building always needs resources.
Yeah.
You know. I think the distinctions I will draw in that context is around investigation and different design of buildings as well. I guess what district plan anticipates about rural areas and to a lesser extent our rural residential areas to be directly associated with carbon production.
And I guess
less so in our rural residential areas because that gives more of a focus on residential activity.
is the other key aspect that the effects of the 2 activities are different.
Correct.
That's probably the more, that's the more, yeah, okay, thank you, I understand. Yeah. Thank you. Any other questions, Mr. Vincent? Anything clarifying?
all good.
Thank you. Thank you, Vincent. Helpful. I now ask the applicant if they'd like to exercise their right of reply and how you might want to do that. Whether you need some time or whether you want to do it in writing or yeah, how you want to take it from here.
Definitely in relation to the APA as suggested by the commissioners. Obviously, I can't provide them right now, so it'll be easier to provide them.
Yeah.
With massive leave to do that.
Yes, absolutely. I think my logic would say is that it's appropriate for that to happen. And if you want to give a verbal right of reply and then reinforce that in writing with those details, that would probably not be unhelpful. Is that in order?
Up to the.
Yeah, it's up, yeah, just, yep. Yeah.
Pass them on to, doesn't it?
Mhm.
What else?
Yeah, yes, yeah. I'll just.
It might be easier to provide the reasons for study. Just to confirm it.
Yeah, and happy for that to take place. And I'm wondering if it, given the APA, but given the other stuff and the complexity around it, that from my point of view, it's if you're happy to provide it in writing, the full reply. I'm not unhappy with that prospect either. And that will certainly enable us to do a site visit in the meantime and those sort of things as well. And maybe with what we picked up, might find the easy way to do it. Take a 5-minute recess for you to work that through.
It would be easiest just to just all in writing, in the writing reply, along with, I would suggest, write up the finalised landscape plan that will fully show and help the have activists and the APA as well. Yes.
And one more thing I think would be useful, a full set of the right drawings, so there's no confusion.
The construction.
Yeah, the height, yeah, no, we got the right set because, you know, yes, yeah, just so it's quite clear in that way, if consent is granted, we can make the right references to the right things. The heights are quite clear, chimney heights, those sort of things, just so there's no confusion.
Easy just to get the, it's.
Yeah. And even just to the extent of like I look at the drawings that came in, not drawings, so the plans that came in the application, and there's the all the flat drawings are all good. They've got measurements and things, but then the height ones, you know, they don't. Be quite handy to. I don't think they do. I know you can scale them. It'd be good. Yeah, just put them on that way. There's no interpretation being made because as good as planners are at doing such things, all due respect to planners and lawyers and other people. If it's written down, it's right. Right, so you happy with that? So
not in the new policy.
yes, yeah, and we'll go and have a look at that. So to familiar ourselves. So that basis, the hearing is adjourned. That's all it has to be, isn't it? Yeah. Thank you. Rightio. Now welcome to this reconvened meeting of the Central District Council Hearings Panel. We're now moving to item number 24.12.2, resource consent 240 200. And my apologies again for running a wee bit late. This is the public convened meeting of the hearings panel called for the purpose of hearing submissions in relation to a resource application for a 2-lot subdivision at 566 Lord of Matakanui Road. I'd ask the Minute Secretary to report on the proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the Planning Officer has been circulated to address the service and all submitters. The submissions received have been identified in the report.
Thank you. The panel may ask questions. Council officers or as consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence. The submitters or their representatives will then be invited to make submissions and present evidence. The section 42A report writer will then be invited to provide a writer reply following the hearing of the evidence and submissions. And the applicant will have a right of reply, but shall not be permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask all parties appearing identify themselves.
I represent the applicants. I made the original application, and with me is Julie McNeil and Andrew May, who are the applicants.
Welcome. Sorry, I'm not very good at writing anymore. I don't know why that's happened. I was never good to start with. It's even harder to read. And
Hayden Stratford.
Mr. Stratford, you made a submission.
Well, yes, we did, myself and my wife. Unfortunately, my wife is working, teaching today, so I wasn't able to make it to make changes. So apologies for that.
That's all right, no problems. Thank you very much for being here. It's a formal process, but we'll won't make it any more than it needs to be. Mr. Dimmock, is this last time we're going to see you?
Yeah, and the next one.
Oh, and the next one today. Not yet. Then right, I'll save those remarks for later on then. Right, I'll move that the section 42A report be taken as read.
I'll second that.
All in favour? Carried. Right, now I'll ask the applicant to provide an overview of your proposal and any evidence you may wish to present and what else we need to know in response to section 42A.
Hopefully, my goes in front of them. We've got my evidence.
Yes.
It's got my reply to Wilden Dairy lodged. They both lodged a submission by time, but it's Wilden and not blocked. But they also lodged to make submissions. So you should have an email from me with our response to Wilden Dairy's late submissions, and you should have also Milkbar Holdings late submissions, which we received yesterday afternoon. And also in front of you should be some extracts from the original water planning and a little map showing the relationship of the site to Thompson Creek and the footages of Thompson Creek.
Yep. So I've got your email dated the 26th of November.
Yep.
Yeah.
And my evidence.
Your evidence, that email, and anything else? No?
Yes. No problem. Late submissions. About late submissions.
I'll work out which one it is. Right, okay. Milkwell and Wilden.
Yeah, and there's a very substantial submission that we received yesterday from Milkwell.
Okay, cool, got it. Yeah, right, thank you, I've got it. Right, we'll get there.
I guess just a preliminary matter, and that is the acceptance of the submissions that we received yesterday, which was extremely late. We only had half a day to consider them. I just really was an enlargement on the substance of the original submission on Milkwell as I was mine. We're just questioning whether you can accept these submissions that were only received yesterday.
I guess it comes down to the rules are around evidence. And are you saying that this is in fact evidence that we were given late? So you're saying it's evidence as opposed?
This is submissions, it says hearing evidence in support of Hamish and attractive submission. So that's, science is even on there, information.
My view would normally be is that in the case, unless it's an expert, it's not typically evidence.
No.
But like, dare I say, you've often told us, I'm not the expert here, I'm not giving evidence, this is my submission. So I'm putting those in the same category as that, I would think. I think that seems appropriate and probably, dare I say, seems fair to me. I appreciate your concerns about it, but I'm sure you'll rise to the occasion and represent your applicant accordingly. So that makes sense. So I'm happy to proceed. Thank you.
Okay, well, I'll just ask, Judy and Andrew to speak to their assumptions, okay? Who's that?
Yep.
Okay, Robertson.
Yeah.
Mr. Chairman and panel, we're just looking at our submission, which we hope that you've read. The when this all came about was we bought the property in Luggett. We eventually retired to, and Andrew was going to move some business up there eventually. So what has come about is the house in Oakhow is now surplus to requirements because we have our home in Luggett. We want to be able to subdivide 566 Lord Takanui Road, so we can sell the house off and maintain the block of land across the road, lot 2, which we call the yard lot, where Andrew operates his business from. He's been operating out of there for 16 years, developed it into a yard, spent a lot of money on getting it right and a lot of hours. We don't want to lose it. It is our livelihood to be able to keep running this business from the yard. And this house is really surplus to requirements. We have an office across the road in the yard, in one of the buildings. We have already rented the house out for 18 months at 566 Water Road. We won't be choosing to do that again. It's an older home that needs to have maintenance kept up on it. We've got the painters in there today just giving it a spruce over after we've had it rented out. And it just makes sense to us to sell the house off. I had a brain aneurysm 15 years ago. I can no longer handle 2 properties, gardens and lawns. So, yeah, that's why I've made that decision. And I just refer to our closing statement, and as we've done that really saved it all. We don't want to sell the entire property as the yard would be lost to the business. It's basically for this. Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, the yard is a valuable asset to my business. I'm in the hub of all my work. It's 20 kilometres from the centre, from my yard to Bullburn, 20k from there to St. Batten, and 20k from there into Mercury Station. So I'm basically in the hub of all my work. So, and it's all the clients are happy because I don't have to travel miles to get them. So yeah, I'd really like to keep my yard, and as Judy said, the house is surplus to requirement. That's about it. Yeah. Thank you.
I'm just looking at a map to make sure I'm getting my bearings correct. I've got no particular questions at this time. I understand what you want to do, why you want to do it.
Yes.
Makes sense. Just had previous applicant in the same situation. The only trouble is what makes sense and what you'd like to do. There's a big book in the road that puts all sorts of adds all sorts of complications to what otherwise should be something people would think is a simple process. Any questions from the panel? It's Mr. Dimmock.
Thank you, sir. We'll just turn to my evidence.
Yep. No, I'm sure you'll take us through the right bits and
Right bits. Right, there's 3 main issues at stake here with this application. One is the status of the application itself, its planning status. The second is any reverse sensitivity effects caused by the existing dwelling area or by the possibility of perhaps a future dwelling with some point in the remote future, possibly going on that site. And there was the submitters have raised an issue about wastewater pollution on the existing septic tank on the site of the zone, or possibly future septic tank on some possible dwelling on the yard, which is on the south side of the Water Road. So we've got two parcels of land completely separate, already surveyed. The house is on the north side, and that's surrounded by Golden Dairy submitter, and the yard on the south side is surrounded by Milk Holdings. The other side. So I'll just deal briefly with the easy part, the wastewater pollution thing. I'd just like you to have a look at just the way extract here has been circulated. It's an extract from the regional water plan, and there's a little map on the left side there showing the two sites in Thompson's Creek and the subsidiary drains of the land into it. Thompson's Creek's the one on the left-hand side. Probably the most highly polluted stream in the many catchment. So that is a bit of an issue. So the thing about it is that the existing dwelling septic tank, not only it's an existing situation, which the subdivision actually is well with it. There anyway, whether or not in the subdivision. The most important point is that it's a permitted activity under the regional water plan. So this issue is a regional council issue. It's not a thing that you can consider here under your district council. It's outside that region. District council, it's a regional council. Any pollution of streams, water, surface water transfers, or wastewater discharge from the 50 tanks on either side. There's a regional council. So if you look at rule 12.8.1.3 of the regional plan water, it's a permitted activity because it was established by the February 28th, February 1 Okay. Doesn't need a consent, it's completely outside the control of the RIC or you. Particularly you, like it's completely outside your jurisdiction. And if you look at rule 12.8.1.4, any possible septic tank on the yard lot on the south side is also a permitted activity because it's more than 50 metres from any waterway. Okay. At least 100 metres away. So it's a permitted activity, both a future wastewater disposal and the existing. That's too bold. So I think that hopefully deals with that issue. So we go for the status of the application, and I agree you to paragraph 11 by evidence. And the rule for a controlled activity subdivision of a surface dwelling is extremely short and simple. It's one sentence. It says if it's a controlled activity of a dwelling already on site and surface to the requirements of the permitted activity. Now the yard is a permitted activity. Employs less than 3 people. So that's the permitted activity. Okay. The site is all of the land in a single record of title. That includes both the existing house and the yard are both on the same title. So they're one site. That's the definition of the site. The different land. Okay. So this sentence is very, very simple. of a dwelling already on site, it is, and surface to the requirements of the permitted activity. Now, the applicants are entitled to read that word as what we call a letter reading. It is what it is. That's what it says. I think it doesn't say that there has to be another dwelling on the other side, that there has to be two dwellings for one dwelling to be surplus. It says a dwelling. A dwelling already on site. So there's no requirement for them to be split up with two dwellings. There's also no requirement for the permitted activity to be a farm, or the surface dwelling to be a farm witness post, separate from the main. If that hadn't been, I mean, this rule's been brought down from the transitional district plans, many territory, district plan, and the transition plan, I think as well. But when this rule was written for the operative district plan, they changed the rule. If they had wanted it to be that there had to be two dwellings and that the permitted activity had to be a farm, the rule sits up. It doesn't. It's really simple. One sentence. So the applicants are entitled to rely on that sentence. I mean, black letter calling on that word. You can conflate the thing to say that's not what it meant, that's not what it was intended, but that's not what the law says. It says a single dwelling, really false, it's surplus to the requirements of the permitted activity. So we have our permitted activity, we have our a single dwelling on a single site. The law applies. And the law says that it's a controlled activity, you get strong consent. So it's my contention that this application is not non-compliant, it is for a controlled activity. If you take a black letter, calling it an interpretation, words as they say, not as someone might like them to say, or how your opinion is talking about, that a permitted activity necessarily requires benefits from on-site accommodation, doesn't say it. And there's lots of permitted activities that don't need a dwelling in the rural zone to benefit from. And the contractor's yard is a prime example. There's no requirement for a dwelling on that yard. To run that yard. So, as I said, it's my contention that this application for subdivision is a controlled activity. Now, there's also a requirement for a restricted discretionary activity to locate this water tank, which we need a 20 cubic metre water tank, because existing dwelling hasn't got one, and the council has a policy on subdivision that existing rural dwellings have to be brought up to a pipeline expanded. There's nowhere else on the site that we can put a water tank that complies with fire and emergency New Zealand standards of access. Yeah, the fire truck right to it within 4.5 minutes. It has to go there. It wouldn't matter where the tank went, which a yard requirements on that house, on that site. You've also got to look at the areas in which reserved the exercise of the first question, and none of them are relevant to the subdivision. Safe and efficient operations of road network, health and safety of people and communities, effect on community value of neighbouring properties, effect on landscapes. None of those apply to a controlled activity of subdivision. So as I said, it's my contention that the subdivision itself is a controlled activity. So we're looking at paragraph 22, recommending report. Yep. We quite happy with a lot of it. Just on there, I won't go through all the parts that we are in agreement with. We can read the obviously with it myself. And the adequacy of servicing, yeah, of an tank, it needs to be 20 cubic meters because because you only need a 30-meter tank if you are feeding into the tank and then pumping from the tank into the house. In other words, the tank is going to be both the fly and reserve and the 10,000 domestic. In this case, the domestic supply is going straight into the house. There's no requirement to have it go through the firefighting tank. So the firefighting tank can just be tanked all by itself and fill it with fire hose as long as it stays full. It doesn't have to be your standard 30 cubic metre tank. There was one other matter, and that was possible pollution of the existing water supply on Wilton between property. It's covered by easements. There's a fence around it. This is a private matter. It's not a matter which you need to concern yourself as far as the subdivision is concerned. Any possible future contamination of the water supply. All the water, we supply the water tests by laboratory, spine, all the water tests, the physical water tests that have been fine in years. There's been no sign of pollution or whatever, and the fenced off and stopping it was actually done by Wilden. Themselves.
Yes, it is.
Exactly.
Yes.
And Wilden was talking about his bore of his was polluted, but that was 2 kilometres away, miles away from Racehorse or something. Completely relevant. So that was dealt with that. So we get to the crux of the application, and this is the reverse sensitive. Okay. Right. This is, well, it's possible sometime in the future that someone, a business, there's no intention really, you actually buy people, you want to keep going.
Yeah.
No possibility that in the next 15 years at the very least, that this is going to be anything other than a contract engineering paper. Yeah, we're talking maybe 20 years' time, someone going to buy that lot and want to put a dwelling on it. First thing we need to say is that this is the Omacau community. We're not dealing with period stuff around else in Cromwell where people complaining about food stores and things. We're talking about people living in a very rural community who are most likely going to be employed servicing that community. And we're going to get people going in there that are almost certainly not going to encourage their own livelihood by complaining. The second point we need to make is that any such dwelling requires a resource consent. Restricted discretionary, the council has the power to turn it down. And one of the areas, we've got a paragraph 28 in our submission. Evidence, one of the areas in which council has restricted evidences of question is item 7. That's methods to avoid, remedy or mitigate the effects of existing activities, including potential for reverse sensitive legal provision of screening, landscaping and methods to avoid. If a future applicant couldn't address that satisfactorily, you have an option but to turn it down. And you have full control over that law. The applicant's also offering a standard reverse sensitivity consent notice, which we have modified. That's on paragraph 41 to look at consent notice, reverse sensitivity consent notice. We've modified that in paragraph A2 to include just about anything you can possibly think of in terms of dairy farming. Have to also people aware that milking sheds and things make plots and weight from the outside on both parts, I guess. So we have a combination of this consent notice here, plus the fact that it needs a resource consent which you can turn down, which you can refuse that don't satisfactorily address resource sensitivity effects. The other thing is, yeah, it's already screened by, there's this carpooling issue, which is screened by the existing shoulder belts, which not what was pointed out was entirely planned. It's true. Yeah. So the applicant is proposing a condition of consent subject to TCC that they establish a landscaping belt on their side of the fence. All the way around, all 3 sides, as a condition of the subdivision consent. So it has to get established before they can get the section 244C application and get title. part of the other. I think I just remembered there was one other issue, and that was Wilden was concerned that the bore could be used to supply a future dwelling on lot 2. If you look at the easement certificate, what was included in it, specific to the northern side, section 2A. And it's only that side of it. There's no way legally that bore can be used to supply a future dwelling or in future activity with domestic water on lot 2, the yard. As you see, benefits of easements through the land, not to titles. You can have private that includes 2 parcels, but the benefit of the easement is only to one particular parcel. In this case, the benefit is only to the land on the north side of the house. There's no issue there with water, with the bore being on Williams property being used to supply any future use on two. They'll have to find their own, which is another thing that's going to make it harder to establish a road. There is no obvious supply of water. Future road. So your planners proposed a consent notice that there be no future residential activity established on that too. Now this can't be applied under coastal law unless it agrees to this. You can't abrogate future rights to some future owner in 20 years' time under the RMA. Who knows the future? If the plan change or is changing the land use, who knows? Whether there's no dairy farming there in 20 years' time, who knows? There could be land use changes. It's just too far in the future. The applicant doesn't accept this. The applicant's position is that the reverse sensitivity consent notice, plus the fact that it needs any future dwelling needs a resource consent, which you can turn down, and the fact that they're proposing screening planting as a condition of the subdivision on all 3 sides sufficiently mitigates any risk of future reverse sensitivity on this site is their position. So that, I guess, just looking at the, just going to go through here, the Milkwall Holdings late submissions. I guess he's talking about the use of existing wastewater remediated field. The septic field wasn't actually remediated. What happened was that the dishwasher and that were bypassing the septic tank and disposal field. All it was is that they just plumbed those 2 into the existing septic tank. The disposal field itself wasn't touched. Okay, it was just inspected. It's been okay. So that's still what we're doing, permitted activity. So, and the other thing is, well, look, the existing dwelling is there. It's existing. Whether the subdivision goes ahead or not, it's not going to make any difference to the status, whatever. But I guess that's all we have to say, really. We think that, as I say, like no weapon, that our proposed consent notice, plus the fact that it needs a resource consent in the future dwelling. And also the fact that the applicants are proposing screening mitigation planting all the way around to assist with any reverse sensitivity effects, perhaps from carpooling or anything like that. And we do find out that the existing milk improvements do generate the most of the traffic and the milk tankers in the early morning showers movement and that kind of stuff. A lot of it long term. Both times. We just don't think that resistance is not going to be mentioned. So that pretty much concludes my evidence. And we'd like to take any questions.
Thank you, Mr. Mick. You are contending that the creation of a second title, and let's just call that, in this case, the extra title being the workshop, the yard, and the future for another dwelling to be erected on it, that,
Potential.
yeah, potential, yeah, that there is discretion under which the council was able to say no. But what you also said, I think, is that taking that matter for discretion, if the screening and other stuff is put in place, it'd be very hard for the council to say no. In fact, I can see you coming back with that application and saying you have no choice but to say yes because of why this happens. And don't take that as a slight. That's just the reality of what this process brings about. So in effect, no matter how you cut it, there is an opportunity here that will enable an application to be made in the future for a dwelling to go on that yard property in the future, and the council won't be able to say no. In reality,
I think, no, I don't agree with that. Like, still can say no, there might be a lot of other things happening, and we took the bit of spend money, is going to be enough, right? Okay, we
yeah.
still have the option, okay?
So taking that.
It doesn't really matter if there is no reverse sensitivity effects or.
Well, I guess it only matters to the extent if it becomes then an argument for someone else or somewhere else, and we start to get the
other thing that was, it would be almost certainly notified to the chairman.
Oh.
Absolutely, 100%. So if there's an argument for all this to happen,
yeah. I guess that if you look at the bigger picture, effectively we get less than a 2 hectare minimum, less than the 80 hectare average. We're already there, but we're doubling it up straight away, effectively.
yeah. That is correct. That is it's our petition, that's a control.
Yeah. No, that's a rabbit hole I'm not going to go down. I think that's something that we'll consider more closely. I thought your reasoning was persuasive. Whether I'm convinced is another matter. So an interesting way of looking at it. I know planners love it when people look at things in a different way of how to do things. And it's not the norm.
I think the whole interpretation of that will have been inflated over the years. It's, you just got to look at what it actually says. It's one sentence, and the applicants are entitled to rely on that sentence.
Yep.
And if you had one to mean something else, it would have been written down specifically in the operative district plan, it would have been specified.
I appreciate that. The only other question I've got is that I know that paragraph 25 that the wastewater system on lot 1 is within lot 1, but it's been upgraded.
Not upgraded, would you explain basically, absolutely, that was the wrong word, it was inspected.
Right, because
Disposal field was inspected, and what was happening was the dishwasher and the sink was being bypassed in a separate tank. So it was then hooked up into the separate tank. The tank itself and the disposal field are not.
so all I'm concerned about is that if it's been upgraded, then it probably doesn't meet.
But it hasn't been.
Right, that's the most. So that's what I want to clarify. You're saying no, it has not been upgraded, so I should change that word to what? Inspected.
Inspected.
Right, it was recently inspected.
Mr. Chairman, when we had the plumber there, we opened it up just to make sure the drain was working
Yeah.
properly. Yeah, and there's nothing done to it,
Yeah.
and we just plumbed it all into the septic tank, this was that in the kitchen sink.
No, I understand that. Just that when
To contain
the
it.
word upgraded, I thought, well, yes, you're right, Mr. Deming, but actually you might have just shot yourself in the foot.
Contained, inspected.
Cool, thank you. Happy to accept that. Right, no other questions from me, panel?
Just a question of clarification, really. If a dwelling was to be erected on lot 3, they need consent from ORC for wastewater discharge.
No, we just said it. In fact, because it's more than 50 metres, many streaming around. There's a little map here. There's a little map showing that it would be at least 100 metres wide. And if you look at the wall, 12.8.1.4. It's a permitted activity of more than 50 metres. It doesn't need to. Once again, this is an RFP. It's not in the wood jurisdiction at all. That's all wood jurisdiction.
And there was the submission from Wilden relating to the wastewater going into the drain.
Yeah, are both committed. That's right.
You're good?
Just one point of clarification.
Thank you.
On that point, Peter, sorry. So there's no bores within 50 metres of the septic tank. That's fine.
Right, thank you. Very helpful. And an interesting, what's the word I want to use? Alternative view to how we've probably treated disposal of surface houses in the past.
Not at start. It's involved in the section.
Yeah.
In fact, what the rule is specifically written was to stop the issue of somebody where there wasn't a debate on the side. Okay.
Yeah.
Something like in the future.
Yeah.
There had to be one existing house on this. Now the council's complaining for them too. I don't know where the two came from. I'm involved in the years.
It's like a lot of things, Mr. Dimmick.
Mm.
And I'm glad that you and I have never been part of any of those things that to enable them to happen. Yes, please.
To the site, if you want to come and inspect it and have a look exactly what's happening and
Yeah, thank you. That we may consider doing that, depending on where we get to with our deliberations. But thank you very much. Appreciate that. Right. So now the submitter, whose name I wrote down. Turn the page. Have to go back and look at it. Hamish. Sorry, Hamish. Mr. Trafford, for you to present your submission, please.
Thanks, Mr. Chairman. Firstly, I'd like to say to Andrew and Judy, like it's through that song process that's not been our intention to interfere with the business at all whatsoever. It's never been part of our thinking whatsoever. So obviously probably created a bit of stress given that there's quite a number of letters that have come back from other people in the community that have been informed that we've been trying to close down the business, but it's not true whatsoever. Our main concern is the reverse sensitivity. We've got a powdering operation on the boundary there, which has been there for 11 years. And it has expanded over the last handful of years, mainly in a response to trying to mitigate how many bobby cars are sent away. So we're trying to keep them within the ag sector and take them through to more of a useful. So the reverse sensitivity and probably a thought for the future, like we take a bit of a long-term view and like at the moment there may not be a dwelling on that proposed lot 2. However, it can't be ruled out that there may not be an application made to put a dwelling on there in the future. And I don't know whether or not if somebody were to apply for a consent, whether or not we would actually be notified whether or not there was. So we may not even get the opportunity to object to that or raise our concerns. The concern is that we get complaints or whatever because of noise or smell or whatever associated with farming. So that's probably the main of our submission, really, as much as anything. just coming back to some of Peter's comments, I think we all have a responsibility when it comes to pollution, not just regional council. So district council does as well too, probably. Moral, maybe not legal, but moral anyway. The 50-metre rule that you talked about, Peter, I'm not sure. Are you talking in relation to 50 metres, what's proposed? Are you able to, through the chair, are you able to explain the 50-metre rule?
Is that okay, Mr.
Yeah, that'd be a good idea because it's, I think I do understand it. So I think it'd be a good opportunity and you're as good a place to do it as anybody else. So thank you.
This is the law and the regional came water, skip up down in most water discharges. Okay, so we'll tell them open public. Also, discharge of human sewage through any on-site water system stored after 1998 into or onto land is a permitted activity providing system disposal field is sited more than 50 metres from any septic. It's a law in the region.
So there you go, will be a copy of that.
If we're going to speak up.
Take problems.
Very well.
Yeah, we'll get you one of it either way.
Yeah.
But, and it's a rule that I'm familiar with, in my real job and other things as well. It's not uncommon. It's used. Might be helpful, might be helpful for you. There are some other, as long as the discharge is 2,000 litres.
Ryan's probably intrigued. Not that it amounts to a hell of a lot, however, but the drain actually crosses the road and it's on the eastern side of the road.
Still making it.
Yeah, yeah, I did say that.
Yeah.
When it comes to establishing trees and central around the perimeter, is there a difference between establishing and established? Like it may take some 20 years to have tree line screening to be a bit of use in the future, so.
Yeah, note that, and that's something that we would have in mind if we were.
And that's probably a matter for the future, but.
Yeah.
My main concern is a dwelling on there that would. I haven't got an issue if it were to stay as a contractor's yard forever and a day, but as we all know that we can't control what happens.
Forever and a long time.
And we own it.
Yeah.
You're right, so.
All right. Thank you. And just find where I put a bit of paper there with it. So the key thing you're saying is the issue about the reverse sensitivity, which Mr. Dominguez provides a condition that would deal to the issues about the noise, the smell and that kind of stuff. And then the only thing that's outstanding from your point of view would be the issue around potential for a house to be there in the future. And without necessarily being able to be involved in the process by which that house would come about.
Yeah. I mean, is there the question to the panel is there a mechanism there that we would have to be notified in the future if a consent was to be sought to build a house? And can the panel guarantee that we will be?
Panel can guarantee nothing. I can tell you that much. There's a greater being than us that will change things in due course. So.
If I may say though, this application is not notified.
Yeah.
It would be very unusual. Council not to notify.
Yeah. But the key thing is your point's made and something in terms of our deliberation we have to work through and say, well, how could that, if we were ever mind to grant, how could that be addressed? Because the concern has been put before us.
And look, I presume it was a limited notification because it was the point that Mr. Dimmock has probably failed to mention, it is a non-compliant subdivision.
I haven't looked at the
Going to
section.
be less than subdivided to less than 2 hectares.
Yeah, the section 42A report, writer will probably be able to answer that better than me having a guess at it, but I'll let you do that, Adam, when you do your part of it. It's a section 95 process that the council works through about what gets notified, what doesn't, and it's quite a regimented and structured way of looking at it that identifies it. So, yeah, nothing to do with Mr. Dimmock. He probably would have a different view on some of these things. In fact, he clearly does, because he thinks it's controlled. So he probably doesn't think it should be notified at all. I think that's what he's trying to tell me. Yeah. All right. Thank you, Mr. Stratford.
Just one question for this reading the dummy. How far away is the house site from Thompson's Creek?
We live, so I would say it would be, at least 400 meters.
Excuse me, but we're elevated.
Yeah,
The house is elevated.
so you're above Thompson's, yeah, I'm just, yeah, having been out that way last week, yes. Having a look at the wetland development, yeah, which is, there,
Right.
Yeah. Okay. Thank you.
Good. Right, now ask the section 42A report writer to respond to any matters raised in the evidence, indicating whether indicate whether your original recommendation still stands or you wish to amend it.
I broadly agree with Mr. Dimmock that there's three main points of contention. Those being the exact steps of the application, provision of servicing and accessibility. I wasn't intending to go into too much detail on the first point around status of the application. Just on the basis that I'm recommending approval and the other two matters of contention are still within the matters of discretion that you have if you consider the application as a controlled activity. Similarly, the same ratification decision could reasonably have been made as well. The controlled activity subdivision considered there was notified and just nothing but notified. So none of those decisions would have been invalidated by considering the application differently. And the same points of contention could reasonably have been made. That being said, it sounds like the panel does want me to comment on that a little bit.
Please.
So in terms of when council applies the surplus dwelling rule, I agree with Mr. that it has been a level of change over time. Currently, our position is that the council ought to be careful in determining that the dwelling is genuinely surplus. And in particular, if the council the permitted activity has the permitted activity that the dwelling has been surplus from has no additional accommodation, but has no accommodation requirement associated with it, or that the accommodation requirement is covered by so agree that the dwelling is a site doesn't necessarily need to have no dwelling on it. Sorry. The site only needs to have, doesn't just need to have one dwelling on it for it to be dwelling to surplus. But we have to be satisfied that the remaining land doesn't have an accommodation. Otherwise, then the dwelling isn't surplus. I will also note that when the site was originally created, this same item came up, RC 100002, it was. And council determined that the dwelling wasn't surplus to the requirements of the land that's now automated. So we've already gone through this argument with this particular site. Yeah, I think it's more reasonable to be more cautious and say that it's not going to sit under that rule. notwithstanding the rest of the.
Just on that bit about been through it before, the surplus one, from whose land?
So in 2010, council received an application to subdivide, well, restrictions. So subdivide the house, the lot that has a covenant, which would be lot 1 of the proposal, and probably lot 2 under the current proposal, from the land to the south of. South. So the land is now owned by Milton. That was applied for under the rural dwelling, under the surplus dwelling law, but council determined that it wasn't. And that it wasn't genuinely surplus to the accommodation needs of that site at that time. Simply a
So it was declined.
it was approved. Otherwise, we wouldn't have this application.
Yeah, so it was approved because of what
It
was,
was approved, but it was approved as, not as a surplus dwelling.
okay.
It was approved under the discretionary servicing law. Because at the time, the average minimum.
Ah. Okay, yes, yeah, okay, yeah. So we avoided the surplus dwelling, dwelling debate because we had another rule that enabled it.
It was assessed.
Some 12, 2 hectares, just over 2 hectares.
Yeah, so it would have been, the average would have been okay. Yeah, so it got there without having to be a surplus dwelling. Yeah, okay, that's all right, yeah,
So
okay.
that other lot was created to create the 2 hectare.
Yeah.
Is that correct?
Yeah, I think that's, yeah.
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 So.
So we avoided it then and you want to avoid it now?
Nice, but just
Yeah.
not quite.
Yeah, right, okay. Sorry, I'll rephrase that.
But as I've said, I think that's not quite semantics necessarily, but I don't think that's necessarily a key consideration. Given government's management. In relation, so moving to certain, if you're happy that as you know.
Yeah.
So I didn't catch the notes, but I've lost track of it. In terms of the proposed 25,000 litre tank for lot 1. On ends, you've mentioned that the existing well essentially provides enough volume and enough pressure that can be essentially denied. One of the purposes of having a reservoir is to help regulate and provide reserve, say the water supplies to development for instance, like there's any downtime. Maintenance or anything like that. So I guess the question would be if it does need to be maintenance, what's the alternative?
And I'll just say through
Now, then you'll have to respond.
Yeah,
what that's going to require is on pumping, they're going to have to pump into the 30,000, have the flood system and then pump into the house, whereas it's never flowing. It's never on demand.
We've got 2 pumps, one that runs the house and one that runs the gardens and have to really struggles with them. So if one pump breaks down, you can always flick it over to the other one and put it through the filtration system so you can still start getting the
So there's a bit of a redundancy.
Yeah, so you can flick them over and get.
It sounds a bit of standard thing, pulled off the roof process so that people pump into the tank and the tank is a dual reserve for water and pumping. In this case, we've got a non-demand system. It's putting it back up. And there's no need to have 30,000 cubic feet, 30,000 meters. The fire service only requires 20 cubic meters of pumping. That's very easy. So you just have a single tank with your fill it with a garden hose. That is common.
I guess from council's point of view, the memorandum of understanding we have with Eds is there would be a 30,000 litre tank on site. So I think my stance would be, in principle, I don't have, and, sorry, go back to that. If there's any departure from that, it is not, yes. So my stance on it is noting that there's the redundancy to mitigate the risk of loss of water supply, there's downtime and the infrastructure supporting that water supply. I think that's okay. I was still watching the panel to consider whether that should be run past teams as well. Just to cover off. It's a little bit of bureaucracy around just making sure that all the points in our understanding and how you ran understanding the fees are.
So Adam, just to pick that up, is that would you be suggesting that the standard consent condition that we use generally with a 30 cubic metre tank, and then with the proviso that if Ben's agree to something different, that takes care of the issue?
It is up.
Yeah.
And that's on the knowledge that if things are happy with a different solution, then might be okay.
Yeah. Understand that.
In relation to wastewater, just confirming that when council is considering subdivision, we'd be looking at whether a development can essentially increase within the boundaries of the lot. And that's with an eye to Australian New Zealand standards 1587 2012. And essentially the same for you. With the existing system, it sounds like it's in good water. And if there was a change of use on lot 2, that would necessitate a system. I'm happy that in principle, you could have a system on that size that complies with 1547 and can be designed in such a way that it could comply with IC's requirements. Noting that that any application of the regional boundary with water discharge is outside of our jurisdiction today. Is there any questions on the case? On the one to questions to?
Any questions on it for that? No? Yep, carry on. Thanks, Adam.
The main point of difference that I consider to be with the risk of versatility, specifically from the use of the existing dwelling, is I take slightly different opinions, Mr. Dimmock, in relation to just the likelihood of people living in sites that have direct link to like rural production and rural economies and that sort of thing. It's definitely likely, but I'd say it's less likely with the current proposal than getting satisfied. So if you've got the person owning living sites, pretty unlikely for that to be associated with the contractor's yard currently. That level of searching goes away. So getting to this point, but I'd say it's a bit less likely than what's put to you. A little bit more likely that you have someone moving into the site that has no relation to the surrounding area. And hence the proposed condition I put in, proposed condition I put in to my draft conditions, essentially looking to preclude the residential use onto, essentially as a way of trying to manage that risk and also noting as the intent of law, the intent of the use of that law to remain essentially the same in the immediate, short, medium term. I do take Mr. Dimmock's points that essentially the applicant wasn't wanting to accept that condition in being advised. Side ability to impose essentially. I do also know that he says that it would be a sort of condition that stays on top for a long time and it's very hard to change. Quite a number of cases which I've read most of them and replied a few back at a bit times. Essentially what they're saying, what the courts have said is with their consent notice, council should be looking to make sure there's been a material change in circumstance which essentially which would mean that having a condition there is no longer necessary or appropriate to achieve the purpose of the act. Giving some examples such as a change is circumstances where they may be relevant. So I wouldn't necessarily, if it was, say if that condition was imposed, people wouldn't mind imposing that or similar condition trying to restrict residential activity. And there's a sufficient change in context, sufficient change of circumstance, then but essentially they say that would be a like valid argument a future owner should raise to say, hey, this is the circumstances change. Therefore, council should allow them to treat it. That being said, it sounds like it's probably not going to be accepting of that condition. So yeah, essentially we're and if the panel's so concerned with the potential effects that residential activity shouldn't be allowed, and the applicant's not willing to accept that, then I guess that starts to have greater questions of whether consent should be approved. That being said, having a look through the conditions that have been proposed, particularly having the reverse sensitivity consent notice
On both lots.
on both lots, as opposed to just the one which I'd already proposed. I think that can work. It just certainly stands as a flag to future owners that there's a future landowners that if I wanted to change the use of the land, these are things I need to take into consideration. On the question around whether or any future owner of the neighbouring land would be notified, if the occasion, assuming that land frame notification tests will remain the same in the future, which they won't. I think each notification decision is made on its own merits. I think if the panels were mind to grant consent sort of without having any conditions specifically restricting residential activity, I think there's ways that the decision could be worded that would essentially flag for anyone down the line looking at a consent application, say, hey, this was a potential issue at the time, and we think there will be merits in the landowners of the surrounding land to potentially have, it's more of a say in that than have more of a say. I think there would be essentially a way for us to flag down the line, say, hey, any person considering an application should give some particular consideration to whether those people are affected by that dwelling, given the issues that have been raised as part of this application. It wouldn't serve as an absolute guarantee to anyone, but I think that would be a reasonable solution, given what we're moving with the application consider on merits. Essentially, the panel signalling to future decision makers this is something that's potentially important. that covers off the points that I wanted to raise, unless the panel has any questions, someone to clarify.
Yeah, I'd just like to explore the lot 2 not being used for residential activity, and you've gone through and indicated that a consent notice to that effect, if the applicant was to agree, wouldn't be fatal to it being removed at a later date. And there's provision for that to happen, has happened.
There is provision for that to happen. It is a high test. But my reading of the decision from the courts is that if the conditions no longer appropriate, if there's been a change in circumstance, means the conditions are no longer appropriate, then that's valid reasons to vary it.
So picking up on that and whether the applicant's attracted to that or not, we'll hear shortly, I'm sure. But that to one side, if we were to enable it with or without such a condition, or consent notice, what does it mean for the district plan integrity and precedence for enabling what can only be said to be significantly undersized lots in the rural resource area? What would it mean for that?
In terms of if the panel approves.
Oh, yeah, and then someone next door finds something similar, or somewhere close by finds a similar type situation and says, well, you know, it was good enough for here, so why not here? And we know that does happen, has happened, and I'm not saying it happened here, but because that's the key thing. That says, well, okay, we might be able to satisfy the applicant, give them what they want here, but what does that mean for our integrity of our plan and for precedent in another situation?
I guess the question, that when it comes down to the future use of the land. Yeah, in this case, the owners aren't anticipating the use of the land to directly change as a result of the subdivision. So, putting rest of the sediments now. So it seems in that subdivision, there is a very limited influence on the character of the area. Notwithstanding, there could be some changes to the character through being will be managed by the same entity.
Yeah. So what you're saying, unlikely to have. So unlikely to have a significant ability to influence or be used as a precedent or erode the integrity of the plan for in the future.
And so I think in an equivalent sense, I think it's precedent. But I'm not satisfied that precedent would be so that it should be measured in time.
Yeah, thank you.
Mr. Chairman,
No, I might just wait for the right reply and pick it up as part of that. Yes, yeah, that's right. No, that's all right. So I might 10 years down the track. No, thank you. Panel, question then. No, I'm not sure. Ian, we good?
oh, good, thank you.
Yeah. Okay, so with that, no more questions. I take it your recommendation is unchanged in terms of to grant?
Correct. I'm in terms of conditions, I think the conditions proposed by us as well.
Okay, cool. Right, thank you.
Oh.
You're going to say, mate? Yeah, I'm just thinking. I've got this fancy new form and I wanted to use it because someone's done a whole lot of hard work to make it. I want to make sure I get this right for once. Yes. Right, I've done that. Now, I'm now inviting the applicant or the representative to have the right reply following the hearing of the evidence. You can, yes, thank you. We'll take 5 to do that. Right, thank you, Mr. Dwight. We're back to hear from you.
We're going to address a few points. We'd also like the hearing to be adjourned and we'll have a reply in writing
Yep, no, that's perfectly sensible. Yep.
So just back a couple of points. The previous history of how we got to this particular title is not relevant. You have to consider the title as it is now. Okay, we can't go back, you know, you have to. And the situation is the dwelling is genuinely service. It's not needed to run a yard. The second is the yard is a permitted activity in the rules. Although we got to plan integrity, it'd be very hard to find this set of circumstances. But contractor's yard and small title and no title over the road, I don't think it's going to have very limited intent because of that. Another global thing, as Mr. Vincent pointed out, these little clusters are not uncommon around and considered on this plan all over the place. As far as we're concerned, yeah, there's never been any complaints. This is the property values, sort of historic subdivision is in most of it well before the district plan. But it's the applicants to that, we're really great about following lots of people living in only smaller lots in the other. So yeah, that concludes one of the brief thing.
I'd like to say offering the consent notices on lot 1 and lot 2 from the gross flexibility. We just, Ed and I just both decided it was good to have the long roads rather than just the one. And we are just not keen on the restricting residential activity on lot 2 at all. We've spoken to a land agent who is in Oakland who said instantly that devalues that block of land by 50%. For their retirement fund, we don't want that to happen.
Yeah.
You know. We just find it's too risky.
Understand that.
Yeah.
And I guess it's always for us as a panel is to explore, to work through those things to make sure that we get the best decision for the right reasons.
Yes, I understand that.
And it's
Yeah.
all I can say is it's always a challenge to try and make sure that what makes sense can actually be enabled.
Yeah, and we also love people living in small blocks in our area. We've got Mr. Peter Kelly, CEO of Central Otago District Council, is one of them. We've got, and I've talked about.
Talk to him about that.
Well, straight out of Wellington, straight into there, you know, people choose to live. You know, professional people come to the community and they add value. That's what we love, you know. We've actually put that in our submission as well, so.
Thank you. I appreciate that. So on that matter, I can now say that your right of reply will be in writing and therefore this hearing is adjourned. Thank you, everybody.
Thank you.
And, you know, appreciate the candidness everybody's shown to help us make a decision. And we'll do that eventually. Righto. We'll reconvene this meeting of the Central Otago District Council Hearings Panel. We'll move to agenda item number 24.12.3, RC 240193 NZ Properties 2019 Limited. This is a properly convened meeting of the Hearings Panel called for the purpose of hearing a resource application for an 8-lot subdivision and cancellation of a consent notice at 634 Argyle Road. I'd ask the Minute Secretary to report on proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the Planning Officer has been circulated to Address for Service.
Thank you. So the following procedure will be followed for the hearing. The panel may ask questions. Council officers or consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence. The Section 42A report writer will be invited to provide a right of reply following the hearing of the evidence and submissions. The applicant will then have the right of reply, but should not be permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask all those parties appearing to identify themselves.
I'm Peter Tippler. I've made the application and also the evidence before you. With me is George Orchardson and Claire Pottinger, who represent the applicants.
welcome.
Then we have Mr. N.C. Weaver, who's our highly productive land expert. And as an observer, we have Access New Planner Management.
I knew he'd get there eventually. Hello, Maddie.
Eddie, you've been replaced.
I would.
Hardly there are no overt influences in the short period of time she's been with the board.
Right, shut up and let's carry on. Well, welcome everybody. You can tell we're not going to be too much on the formal side of things if he gets his way anyway. The panel, Neil Gillespie, I'm the chair of the council's hearings panel. Martin McPherson and Ian Cooney are also councillors and members of the panel. Karen, who makes sure that stuff works, and Anne, who makes sure that we don't get it wrong. Or sorry, don't try and do it wrong. Not that that'll ever happen. And of course, our report writer, Tim. Right, I'll move that the section 42A report prepared by the planning officer be taken as read. Ian, second that. All in favour?
Aye.
Carried. And if that, hand over to you, Mr. Dimmock, to continue with the proceedings. That's quite right, yes.
Okay, perhaps if you turn to page 239 of your agenda, it's a couple of things, otherwise you might want to one for it. And my evidence. I'm just not going to read every word of this evidence. I'm just going to go through and highlight some of the main points. And that's speaking of the MC and the applicant, George, at least they have a say as well, if I can say something about the meeting. Okay, well, it's pretty clear that compliance with the national policy statement on highly productive land is the crux of this application, okay? Otherwise, it fully complies with the ADP and would have been processed under delegated authority as an expected activity. The minimum lot size, the smallest lot taking, okay, and the average is way over the average required. All pretty straightforward subdivision if it hadn't been subject to the national policy statement. So turning to paragraph 15, the fundamental driver behind this and this irrigations. And it's replaced with a series of a gravity fed scheme out of a series of takes and normal distribution water rates fed by gravity, cheap water. Now it's been replaced, it's been cancelled as a result of the Lindis minimum flow on court hearing. And it's been replaced with every individual landowner along the Lindis is going to have to think a bore field within the Lindis River Aquifer, get power to it and pump. And basically, the gravity distribution is gone, so they have to be by pumping and spraying, irrigation, put it over, etc. So the story is that basically the cost of this water, there's another source of water in the valley, which is also applies to this particular site, and that is there's a Ardgour Valley scheme. There's a bore field beside the Clutha River at the junction with the Lindis, and then there's a pipeline there way up Ardgour Valley, and it's pumped all the way up the valley. It's another huge, very costly water. A lot of the energy costs involved with both of these sources of water. So basically, the current reasonably intensive partial farming, sort of discount continuing with this new water regime, the water's just far too expensive. So this is what's driving this application, and that the cost of the water is going to be intensification. And I guess this is going to be an interesting segment with manufacturing here as well. Yeah, the harder and more expensive the water gets, the only way to use it is to intensify. So whether that also has this issue, okay? So if this subdivision doesn't go ahead, then the applicant advises that the property will simply revert to low productivity dryland fund. The perverse outcome in view of its status as highly productive land under the national policy statement for highly productive land. In terms of the planner's report, we agree with about 99% of it. Paragraphs 17 outlines all the points which we agree with. I'm not going to go through that and then the great detail. You can read the work for yourself. So we come to the crux of this application, and that's compliance with the national policy statement on value productive land. So there's two clauses to deal with, 3.8, which is to deal with subdivision, and 3.9, which is land use. So 3.8 says that a territorial authority must avoid, it's quite a strong statement, of highly productive land unless the exemption clauses in 3.8 apply. And clause 3.8.1 states that the applicant demonstrates that the proposed lots will retain the overall productive capacity of the site over the long term. Whilst the applicant's contention, and that's also supported by our expert here, Mr. Weaver, that not only will they support it, but they'll enhance it and they'll enable the very realisation of the site's productive capacity. And I note that, reporting planner has accepted Mr. Weaver's findings. There's been no request for peer review. He's accepted as a local expert. So this application has been a little bit of a saga, just a bit of background here. There's been requests for further information. There's been an ongoing series of draft submissions submitted, which we'll agree to, and then they're changed. And then we had a meeting in Cromwell prior to this. So it's been something of a saga, and the reason that we're here is that basically we understand that the staff accountable of making the final determination of compliance with the EPS, and they will adhere to make that decision. That's the reason that we're here. So, the main issue seems to be with those front lots 1 and 3. Background information and talks where we're heading. So they had a few issues. The council planners had a few issues of those lots remaining productive in the long term. But as the Weaver report discusses, there's a market for smaller non-corporate operators that can establish on these sites at a lower cost than this was than large corporate operators on larger sites that still remain high findings. As part of the ongoing negotiations prior to this hearing, we supplied a breakdown of all the lot sizes in the district's established horticultural and viticultural areas. That's Teviot Valley, Greensfield, Felton Road, with the Melbourne going up by them. And it was demonstrated that there are many, many lots of similar size to these, and even smaller, in those highly productive areas. And while it could be argued that they were granted prior to the EPS, which the outcome of the case, or other cases they wouldn't be subject to it, it does demonstrate that lots of at least 8 hectares can remain productive over the long term. And you can just drive around and see all 2 and 4 hectare vineyard and cherry blocks. And the other thing you need to take into account is that, if a larger a subdivision doesn't preclude a large corporate outfit establishing on these sites, they can buy 3 lots or 1. The other issue, which is extremely common in this district, is that you get corporate viticulture or horticulture guys, they'll own a whole bunch of smaller lots scattered all over the district. Now you've got vineyards in Gibston, Isa, down here in Alexandra, and all owned by the same corporate outfit, be it be Gibson Valley or Big Paddocks or Charter Farm. Some of the larger big corporate overseas operators now, again, they own little sites all over the district. So they could buy one of these lots and it could be incorporated into a whole bunch of other lots which they operate, or they could buy 1 or 2 or 3 lots. So this subdivision is not being as we market it as clearly. The only thing we're providing is access and irrigation. No power, no telephone, no domestic water, no identified building platforms, no application for land use consents for residential building platforms. These are the things that we would do if we were going to set it up to be so-called residential lifestyles. It's not. They're huge, they're the smallest ones. The very smallest, 8 hectares. So it hasn't been set up. The automatically people go in here and buy residential activity. The other way we're going to manage this, and this is that suggestion of the planner, is that we're going to put like consent notice on taxes, which I'll discuss later, requiring establishment of some productive activity on these sites before anyone applies for it. Discussing the exact wordings of the thing. The other thing to be aware of, course, is that any dwelling on these sites does require a restricted discretionary resource consent application, which enables you to ultimately refuse consent if there's not sufficient provision for services and reverse sensitivity effects on rural amenity and built form in the environment. So they have to apply for a consent which is not guaranteed. But the other thing to bear in mind, and this is like a belt and braces thing, is that when we look at section 3.9 on the NPS HPL, we're going to paragraph 31 of my submissions. And that provides that territorial authorities must avoid the inappropriate use or development of highly productive land that is not land-based primary production. In other words, it applies to all regions. It doesn't just apply to some, it applies to land use, and the dwelling is a land use. So unless a future applicant, and there's an out in that they can only allow other land uses if they support productive rural activity on the land. That's in clause 3.91. So there's an exception for this. Was that they have to avoid land uses provided that they, unless they are proven to support productive rural activity on that lot. So unless the future applicant for residential activity on any of those lots can demonstrate that a dwelling is necessary to support activity on that lot, horticulture, viticulture, on that lot, some productive activity, the council has no option but to refuse that. They have to prove that the dwelling is necessary to support the productive use on that lot. That's under the national policy statement, which overrides anything in the district plan. You have to take into account the county law. And that's provided for section 104B of the 3 of the RMA. When considering application for a consent, you must have account for a national policy statement. You must. But they've got the basis in here, consent notice that says they have to establish a productive activity on the site before they can build. And secondly, they have to prove to you in the future when they apply for the resource consent to build. And dwelling is necessary to support the activity on the site. Can't just put a dwelling down anything. It's lifestyle. In other words, you can't have a lifestyle lot subdivision with set by property under the NPS HPL. Servicing of the lots, well, as I said, there's no proposal whatever to service them. The applicant is not wanting to get involved in domestic audits. It's a complete nightmare under the Water Services Act and Tamariki Arroway. It's the most gigantic bureaucratic nightmare that you could possibly ever get into. Okay, you just don't want to go anywhere near there. We're advising all our clients and rural subdivisions to go for each individual lot has its own law if we can possibly treat it. It's just perhaps, and there's personal liabilities of 5 years in jail and $200,000 fines if someone gets sick, drinking your will. And if you're in a community speaking with this, tested, it's got a management plan, it's just an absolute nightmare. So the applicant just doesn't want any part of this. Okay? Here's the land, you want to put a house on it, and we can prove that the council that it's necessary to be a productive use, or we're going to find one for If we provide it, what are that? Because the first signal back to the council, we're advertising that it's for residential, primarily for residential use. So it's a perverse outcome.
So the proposed conditions, they're all fine. But there's this, the condition about, proposed condition about restricting residential activity until we establish certain forms of activities to restrict it. And talks about, vineyards and horticulture, as in Mr. Weaver's, report and the supplementary report that he produced, which I think we've got a copy of. And there's lots of other issues, but we've been high productive land, all with great irrigation. Can't necessarily restrict yourself to just those two residences. There's a lot of other options now with climate change now, and Mr. Weaver will be very happy to answer questions to you about some of these other options. And really, we don't want to restrict it to just agriculture and horticulture. That's too restrictive. So look at paragraph 39 is our, what we're proposing in the way of a consent notice. If there's provided the establishment of any residential activity, that's in the dwelling, then constructed on off 1 to 7, a land-based primary activities, not specific, it's got to be land-based primary activity, and that's words taken out of the NPS HPL, must be established on the lot. And suitable infrastructure must have been installed to support the use of that lot in land-based primary production. And a land-based primary production activity must be maintained thereafter on the lot, and that gives them the option of changing things. You don't want to specify it, they might. Who knows what new crops are being, what climate change is going to be. I mean, as we said 30 years ago, who would have dreamed that you could commercially grow grapes in such a day? You know, no one ever believed it. Look at it, so they need the flexibility to establish something other than just viticulture, horticulture, and also to be able to change it. Change. So now that the double label here, we've got this consent notice, which is really not necessary in terms of the NPS section 39. So they have to prove to you two things. A, they've got to establish and maintain and primary some sort of productive activity on the site before they can build. And B, they've got to prove to you when they apply for the consent that dwelling is necessary to support this primary activity. If it is, yes, it's fine. Complies with this thing. The lots themselves fully comply. We're not carving this thing up into 2 heaping lots, okay? Lifestyle lots. And that pretty much concludes my evidence going through it. Now ask George to have a say a few words and maybe farewell.
I'm gonna have to, sorry, Judy, the meeting is running over time.
Yeah.
I'm gonna have to leave, so my apologies, but.
Sorry, we're running late, but it was Mr. Dimmick's fault from the previous,
I was from the previous.
was it? Oh, humble apologies.
It's his last day here and giving brief.
Yeah, just going on from where Peter, they've gone it. I mean, everything Peter's said, I think it's explained, pretty much what the thoughts are, where we are, and so the wetlands and the field improvements. And it's quite productive. The highly productive fact for that we've got written in there, it was cherries and grapes. In that terrace region, coming from a background in property, hops have been really pushed on in this area. Now, from the youngest kid at school, I've actually become really friends with who I've got to know the guys running Midland Seeds. It's actually a Dutch, they're contracts for a Dutch company doing seed crops. They've approached me for 5 hectares for carrot seed, a specialist block. One, because we're hidden over that side, we're not contaminated the carrot seed that we're on the other side. Some of the money that he's offering for just that little block for 6 years for the carrots is money I do believe would be hard to beat in any other crop. Now that's something that probably wasn't there for offer 18 months ago. And that's how much I'm seeing the change in land use in that area. There is so many other different crops that could be grown, and whether it's raspberries, blueberries,
And that's where, that's the only one I'm sort of concerned in there, that we don't know what the future is. The future is very much definitely horticulture for that lot of land, driven by the high expense of the water going forward, as Stu quite aware of the race going to the Argyle Valley, that is in 2 years' time getting stopped. We still have the right state water, but not out of a gravity fed system, which that gravity fed system is probably one of the cheapest water systems I think I've ever seen. But yeah, running a grass based system, even under that, it still is quite demanding. The only thing is that the farm does not make money. But so I think that's the biggest thing I see. And all those lot sizes we've taken, like with what I've had Queensley working with, is there is a certain amount of land left over residually that we're really looking at anything 5 hectares and upwards of good horticultural land, which I think the smallest lot's 8 hectares. So there's still another 3 hectares within that lot that for a house or pack house or sheds, drying gear or whatever it is that you need for that farming operation. So yeah, in terms of that subdivision, look, I see all those lots as one of the things I love about all those lots itself is you do have some highly productive ground. If I could expect, you're definitely not looking at a rectangle block with these corners. So that's probably really what I've got to add is, you know, with knowing that ground and those soil pipes, you can have water that can grow even.
Well, I just want to emphasize that on that we don't have a crystal ball to really assess what crops will be grown in the future, and it's having available. So these plots have got excellent water, excellent water supply, they've got excellent soils, climate's great for a multitude of crops. So that opportunity to grow the emerging crops in the future, whatever they may be, like go back 30 years and cherries were much more than just a domestic market product. And I reckon that the curve would drop out around about 3,000, so I went through that pretty badly. So we don't know what those future crops will be, but the soils are excellent, there's plenty of water, climate suits. I just think that there's great potential in that land that will be unlocked with a subdivision.
Water is the key, obviously. And with the advent of the gravity, and you're right, gravity water will be the cheapest water you ever get, hands down. But yeah, that's not going to happen going forward much, is it?
What's that?
It's not going to be an issue going forward in some places anymore.
No, we're actually quite lucky on that farm there that when we bought it, look, I was actually from 2 owners back, I was involved in them looking at putting water on that farm. They decided not to sell it on. But so one of the previous owners, so that's pipe from the RPL, well, it's pipe from down to Cooper, and it's piped up to the Jollies farm, Bruce Jollies. So we were holding down there, and that splits off, and we've got basically 3 shareholders, 3 lots of water, A, B, and C shares. So C comes our way, B goes to Bruce, and the other one heads off the other direction. Now that was set up and established, I'm guessing here, about 9 years ago. And that's when this farm here, they wanted to convert it to dairy. That was the idea, right before the dairies were crashed. But now when we bought the property, the guy we bought it off, he had that water right, and was sitting there going, this is really expensive to hold, and I want to do horticulture up on the top terraces. That water was always planned to go on the top terraces above us. And I sort of said, well, hey, with the limits water like it is, we don't know what we're going to lose. We're going to lose our water consent, we knew we're going to lose something. So we said, well, we're not prepared to buy the property without securing water. But so back then, we split that water right, and this is working on the agriculture system, not knowing that since we did that, power prices have gone through the roof. The expense of actually operating it doesn't actually, it's too expensive to operate for our horticulture, for an agriculture system. So we always had that up our sleeve, which is actually costing us $30,000 a year just to have. And also we're not even using this. The dam is on our farm, pump to the farm, and it just sits there. Matt, the neighbour, is using it for his grapes up above us. So that with that water right, that's what's really made the subdivision really work, because we've got that to the top part. Now with the Lindis water right that we had, we haven't lost our water right. We've lost our ability to take it from a gravity based system out of the Lindis River. That's what we've lost there. So we've still got, which has been pointed out in the original application for when the Lindis River had an environment board. They've done all the research and all the drill test holes right throughout the valley and pointed out where the water is and where we can get it from. So that's what's really made this the subdivision for horticulture, what we are asking for and applying for. We've probably still got around about 20 litres a second extra water up our sleeve. There's another Wainui water right. So that's one thing. When I first phoned Peter to say, would you be happy to come back on board here? He said, right, stop you right here. What water have you got? Because there's no point you even coming down to see us. Can you tick that box? And I said, I could probably pick that box for our farm and probably half the neighbour's farm as well. So yeah, that water right was that original back 5 years ago, like making sure we had that 41 litres a second coming from that other right there was pretty much is the key to making this one work. Without that, we'd still be able to do it, but we wouldn't be able to. We wouldn't be able to do those amount of lots in agriculture. I mean, so that box there, water, with well and truly tipped that box in every way.
You just mentioned the dams on that on your land.
It's a holding dam. So we've got a holding dam. If you look, if you got the map in front of you.
Yeah. I'm just interested. That's right.
That's one of where it is.
Yeah.
Zoom out a wee bit. Okay. Right. So this is the pipeline coming up that side of the river there.
Yeah.
And it crosses over about there.
Yeah.
And the dam is there. Right. Is there pumps? Yeah, right there. Just there.
Yeah, okay, right, cool.
So
Yeah.
it's a holding dam there, and then it pumps up. So all up at the moment with a pump shed there, and it's pumping up
Right.
to this block here.
Yeah. Usually you can see a bit of water, but the topography is not good.
Quite small.
Yeah.
To the point when we were looking at shooting off that run above as it is things. As we were turning it on, we all thought we were going to have to make the dam bigger.
Yeah, okay.
The engineers that came, this is if we were to keep running as we were, said instead of going 150 pipe to your public pump shed, go 280.
Yeah.
And that'll allow for holding extra water to save the evaporation from the pond.
What they call it, two there, I think, it's just a little holding.
Yeah. And that's in lot.
That dam's now, well, it's in, sorry, I've got lot of
Lot 8 or 7, lot 7, yeah, lot 7, yeah, you've got it, yeah, cool, that's right, good, thank you. And I suppose, yeah. And the only thing I guess is that from the application that was lodged, which said lots 1 to 7, intensive horticulture and viticulture, you were saying, actually, no, not just that, that's too restrictive. Yeah, so that's, yeah, right, okay, cool. And we've heard from Mr. Weaver that I think I heard him say basically, if you put water on the soil, it'll grow. And water seems to be taken care of. It can grow. Yeah, okay. No, I have my head around what is proposed. And I guess too, the key thing for me is that what you're saying is this is not about anything about lifestyle. This is about making productive use in terms of the national policy. And what people who come next do is what people come next do. And the applicant's saying that there's enough, what's the word, hurdles in the MPS that'll make that difficult just to make it into a lifestyle block and do nothing with it. Yeah. And
it's recognised for many years that block for horticulture and Pino went back to the Grey Power days when he owned it. We've got reports from them right through to when I've been going down here asking for the client whether this Pinot country should be the best horticulture country, and that was an old guy in the area. So
There are a few old guys in the area. I'm not looking at anybody in front of me. Panel, questions?
No.
Ian? No?
Any clarifications that I need to ask? Scupper's going to change the EPS.
So Chair, that point of clarification is, what other descriptor would you, other types of crops? Agriculture or field crops or something, what else would you want? Because everything you described, to clarify, everything you've described in terms of carrots and that's within that horticultural descriptor. So
yeah,
is there another?
I think that's what I want. It's not open because I don't know what crops people wanting to grow in here. I mean, you could put strawberry fields on there. You could put raspberries, which is a big thing that no one's doing down here. And that's like yeah.
But when you consider that all horticulture is intensive agriculture, that's what horticulture is. So it's intensive crops. So what we've taken for
Agriculture's a little bit different.
What's that, sorry?
Agriculture's a little bit different.
that's extensive planning, whereas we're talking intensive. The kind of adopted the wording from the NPS right and the proposed incentives.
And that's the land-based primary productive activity.
Yeah. That's just straight out of the NPS. I mean, the NPS doesn't really about horticultural, vegetable growing or whatever, you know, it just says any place for that. The rule is.
My point was just to clarify. Once, it's a matter for the panel to determine.
Yeah, and it's certainly a matter that we want to, like the MPS is still, there's still information, or the way that you implement the MPS on HPL is still being informed. And, you know, what you've said is, I'm informing you that the way you could do this is by using the word straight back from the policy itself. Yeah, could be helpful. You think though that if you did go down that path, you'd have to make some reference back to saying as defined by, because to make it quite clear, because if you're going to do that sort of thing, it just seems that what Mr. Weaver thinks is primary productive activity and what I think may not be the same.
We would accept a mine case of
Okay, nothing else from us? No, all right, I'll hand over now to Tim I've got this fancy new form I've got to use. What I've got to do, it says, invite the report writer to respond to any matters raised in evidence indicating whether the original recommendations still stand or if they wish to amend. Bob.
My opinion, the proposed subdivision will provide allotments that are consistent with district plan requirements on lot sizes and averages. On that basis, I consider the effects to be no more than minor and also acceptable in terms of assessment under section 104.1.1a. It represents, with the effect of the NPS HPL, it represents a subdivision that's fairly typical of the rural resource area. I've assessed the proposal against the relevant objectives and policies of the CODC plan and also the Otago regional policy statements, and I consider that as not contrary to them. In terms of the NPS HPL, as discussed, there's a very strong emphasis placed on avoidance. Avoidance of subdivision, and there's also a relatively high bar for what the applicant needs to demonstrate in terms of retaining the productive capacity.
In acceptance of Mr. Weaver's assessment, I am satisfied that it has been demonstrated that the long-term productivity can be maintained on the allotments. However, the wording of the policy statement itself uses the word will, so it's more a question of how is it demonstrated that it will be retained. In this instance, I conclude that the proposal would only meet the provisions of the NPS-HPL if there's the if the productive uses are established before any residential development, and on that basis, I've included a recommended condition that's 11C on the draft. And the intent of the condition is to maintain the long-term productive use of the soil. The applicant has volunteered an alternative, which also seeks continuation of agricultural activities and offers flexibility, which I think in the circumstances is a positive thing. However, I feel that condition lacks parameters and doesn't clearly provide a differentiation between productive uses and perhaps other uses such as rural lifestyle. Should the panel consider it appropriate, there may be the ability to compromise. For example, as discussed, land-based primary production could be further defined. And I feel in the circumstances there could also be something added to that condition to address possible changes at the central government level. Be speculative to mention what's happening there. However, I understand the NPS-HPL is currently being reviewed. Overall, provided there's an appropriate consent notice condition, I stand by my original decision that original recommendation, that the application be granted for the subdivision, and also the other part of it was for the cancellation of the consent notices that are currently on the title.
Thank you, Tim. You mentioned about the wording for the conditions. These 11C. Yeah, 11C instead about needing to consider also perhaps rural lifestyle. I just wasn't sure what you were referring to when you made that observation.
Sure. I think in the guidance around the NPS-HPL, it does mention rural lifestyle development as a threat. And I think my main point is between what I'd recommended and what the applicant's willing to volunteer, there may be, in my opinion, the applicant's suggestion lacks parameters that would perhaps prevent rural lifestyle.
Right, sorry, I missed that word prevent, because I thought you were saying I should provide for it. I'm going, no, that doesn't make sense to what I think the NPS says. So no, I heard you wrong. Thank you. Appreciate for clarifying that. I think also what you did say is that somewhere between what you've got and what Mr. Dimmock's proposing, there's some scope to give the right outcomes.
Yes,
that's what you were saying. Okay. Right. And
Are you satisfied that there's enough irrigation water available for the intensive agriculture to take place on each of the blocks?
Yes, with the application, Mr. Weaver has provided a breakdown of what each of these future allotments will require, and I accept his opinion on that.
That is also going to be subject to a condition of the subdivision consent, and that we have to set up a ownership and maintenance structure for the scheme. Have to be in a corporate society or a company from then on rules, and then that will distribute it, and as part of the rules of the company, there will be the allocation of each lot, the setting the rules. And we provide a draft of that to the council file has been signed off for section B to be proceeding with.
yeah, all good.
Yeah, my thoughts, clarification, thank you.
Thank you. Now I'm going to pass back to the applicant for right of reply. Do you need any time or you're all good? Yeah, just one thing to consider. I meant to ask earlier, but I'll do it now so you can cover it. You mentioned 2 pieces of work by Mr. Weaver. I got one, which is Appendix H in your application.
Another report provided. And the meeting that we had was a request from council, but it basically been incorporated. We had to come up with a revised assessment of environmental effects. So if you get the latest assessment of environmental effects, it incorporates the findings of the second. That was provided as a report.
Excuse me, Peter, was that via email, was it?
Yeah.
Page 421 of the agenda.
Oh, have I missed it? Sorry.
Easy missed it, took me a while to find it.
Is it? Oh,
Yeah,
well, at least I was looking in roughly the right place.
yeah, supplementary report.
That was provided just by the meeting.
I found it.
Yeah, it took me a while, I was trying to.
Sorry, I just was mindful you said there was 2 pieces. So, yeah, so, I gave you, we'll adjourn while you, yeah, cool.
Proposals like you perhaps suggested that the consent notice say, whoops, productive activity in compliance with the NPS HBL must be established on the.
Sorry, point of clarification, if that's okay. Through the chair. What that actually means is forestry, agriculture, pastoral, horticulture. That's what that definition in the NPS means.
Well, that's that one stuff like the all sorts of all crops.
Yeah, just so that you're clear about what that actually means.
Forestry, what?
Forestry, agriculture, pastoral or horticultural activities.
Yeah.
As defined in NPS HBL.
That's what's primary production, land-based primary production.
So what we're saying is land-based primary production as defined in the NPS HBL.
Yeah, I hear you.
Okay.
Yep. Yes. Yeah. But what you're really saying is Horton Vit on its own is too restrictive, and making sure to be able to grow hops, carrots, whatever it is. Although carrots might be horticulture. No, are they?
Yeah.
Well, yeah.
And forestry is
Yeah. Okay. Yeah.
Okay. As they provide highly productive use of the NPS HBL.
Okay. No, thank you. I hear that.
Okay. So that.
Simple.
There's
Right.
a suggestion on the table.
Thank you. The decision of the hearings panel is reserved. The formal decision will be in writing and available with a statutory 15 working days. In the event the release of the decision is delayed, the applicant is advised to delay the hearing is now adjourned. Thank you very much.